I am for the appellant. I have challenged the order of the Lord and Single Judge, Annex 3. Yes, sir.
The interim orders and wicked. It goes without saying that the substance shall be at liberty to proceed in accordance with law. Once.
Yes. And I have challenged the order of the Lord and Single is Annex 3 of my appeal petition.
Yes. And in section 3 you have challenged.
Yes, madam.
Yes.
Page 1113, Annexures 3.
Yes. We are there.
Yes, madam. Paragraph 7, page 2127 of the judgment. That Annexure C, Annexure 3. Well, I got it. Annexure page 7, paragraph 7 of 127 page.
Yes.
Paragraph 7. I have heard Mr. S. Ryle on counsel for the petitioner and Mr. S. Misral on counsel appearing for the opposite part 2 and 3 at length. Having gone through the materials available on record, this court finds that petitioner by office order dated 5/7/2017 under Annexure 5, though was put under transfer, but petition was never relieved in terms of the said order. The said fact was also admitted by the opposite part number 2 and 3 while providing the instruction to this court by letter 11/8/23. My lord, I have already annexed that instruction, Annexure 4 series. May I kindly see page 129.
There was an interim order passed by this court on 30/10/2017.
No, 25/10.
25/10/2017.
Yes, ma'am.
Yes.
And only disputed question is, and that is under Annexure 4.
Only which it appears from the order that the person was transferred from place A to place B.
Yes, ma'am.
It is the finding of the learned single judge that though there was no relieving order granted.
Yes, ma'am.
Issued. All right. So he was not relieved according to it appears from the order.
Yes.
Now you have denied the payment of salary for that period.
No, relief order was issued on that date. That has been annexed in my Annexure 4 series, page 129. May I kindly see?
It was there in your counter affidavit.
Lawrence is hold that the no transfer order was issued. Relief order was not issued after the transfer. But the relief order is issued on the same day where she was working. Page 131. Annexure 4 series, page 131, may I kindly see? Office order. That is the relief order.
Who was opposite party number 2?
University opposite party or private respondent?
Who was opposite party number 2 in the writ proceeding? 2 and 3.
Read petition,
Yes.
Vice Chancellor.
All right. Come to paragraph 6.2.
My lord,
Come to paragraph 6.2 of the order at page 126.
yes, ma'am. Yes, Mr. Law and Counsel appearing for the opposition 2 and 3 produce the instruction provided by the University by letter 11/8/23. Basing on the said instruction, Law and Counsel appearing for the opposition 2 and 3 contended petition from the 5/7/27 was never relieved. That has been stated, but we have filed that instruction in that writ petition, which we have already annexed in annexure 4 series of my appeal memo. May kindly see one page 131. That is the relief order.
So relief order you may have kept in your file.
No, ma'am. That was
No,
filed.
this is what is there.
No, that was filed.
Ah.
My Lawrence single judge hold
File.
that is a transfer order.
You might have prepared a relieving order without issuing that to the writ petitioner.
My lord, transfer order was issued by the Registrar University.
Yes.
Relief order was where she was working. They have issued office order. My lord, one page 131.
Well, then what about this 6.2?
My lord, that has been
These documents are new documents, it appears.
that was a statement of my council of the university.
All right. So we will allow your, we will consider your writ appeal only after you take action against your lawyer.
No, my lord. No, that is wrongly interpreted.
What is wrongly interpreted?
That is, we have issued relief order. That is
Seek review of the order then.
My lord, may kindly to one page 131. That has been.
See, Mr. Counsel, it is specifically mentioned that Mr. S. Mr. So-and-so produced the instruction provided by the university by later dated 11/8/2023. Where is that instruction?
My lord, kindly see one extra 4 series. May kindly just.
Mr. Where is this letter? 11/8/2023.
On page 130.
Page 130.
Yes, ma'am.
And annexure 4 series was there before the
Yes,
learned
my
single
lord. Yes,
judge.
I have filed in this.
Annexure 4 series was there before the learned single judge.
Yes, my lord.
It was there.
Yes, ma'am.
Which series you show?
That was in a separate affidavit. It was filed.
Separate
as per
affidavit,
instruction
that was
of
not
the-
forming part of writ.
My lord.
Your counter. It was not forming part of your counter.
No, it was not filed in
Ah.
counter.
Then how did you file?
It was separate in, as per direction of the honorable single judge.
You seek a review then.
Now we have page 130. May kindly see 11/8/23.
For consideration of any document, affidavit would suffice, or you have to bring it as counter.
A letter is available in this.
Maybe
Yes.
any document you file before a court
Yes.
for
ma'am.
consideration, is it affidavit or counter affidavit? It should form part of record for by filing counter affidavit.
And affidavit is
That will suffice.
yes, ma'am.
I don't know which rule it provides.
No, only letter is available 11/8/23
I am at loss.
along with other documents.
Yes.
Page 130.
We are imposing cost.
My lord. Page 130.
We are going to impose cost, Mr. Counsel.
My lord.
We are going to impose costs. देखो,
My
the
kind before see.
Orissa University of Agriculture and Technology has referred this intra-court appeal against an order of a learned single judge of this court dated 14/8/2023, passed in WPC number 41812 of 2021. Stop. By the said order, learned single judge, where is it? Sorry, order dated Sorry. order dated
14/8/2023.
passed in WPC number 41812 of
41812 of 2021.
2021.
Yes.
21. By the said order, learned single judge has allowed the writ petition filed by respond number
1.
filed by respondent number 1 and respondent number 1, while rejecting the stand of the appellant that the said respondent number 1 was not entitled to pay or entitled to salary for the period 4/11/2017 to 27/5/2019 on the principle of no work, no pay. So stop. Learned single judge, however, taking into account peculiar facts and circumstances of the said case, had directed the appellant to pay 50% of salary as due and admissible for the period 4/11/2017 to 25/7/2019. So stop. Next. It transpires from the impugned order passed by the learned single judge that learned single judge has learned single judge took into account a statement made by Mr. S. Mishra, learned counsel, appearing on behalf of the university based on instructions provided by the university by later dated 11/10/2023 that the petitioner was petitioner in terms of the his or her in terms of the transfer, that the petitioner was though transferred by an order dated 5/7/2017, he was petitioner stroke writ petitioner कर दो, writ petitioner was never relieved. So stop. It was, however, submitted that since the petitioner was getting salary from the fund provided by the Indian Council for Agricultural Research, the same was withdrawn with effect from 1/4/2017. What is this?
The post was withdrawn.
Post was withdrawn.
When she was transferred, before that his post was withdrawn by the funding agency ICR.
Post was withdrawn with effect from 1/7/2017. So stop. The short facts of the case are that the petitioner, that the respondent was working under the university and by an order dated 5/7/2017, he was transferred to Chiplima So stop. A representation was made by the respondent soon thereafter on 6/7/2017 with a request to cancel/modify the order of transfer. So stop. The respondent had approached this court against the order of transfer earlier by making an application by filing a writ petition giving rise to WPC number 13570 of 2017, which was disposed of by an order dated 10/7/2017, giving the respondent a liberty to make a representation before the authorities concerned. Full stop. The petitioner, the respondent had approached this court once again by filing a writ petition giving rise to WPC number 21109 of 2017. Full stop. While issuing notice to the university, the court had passed an interim order dated 25/10/2017 to the effect that the said office order of transfer dated 5/7/2017 to the extent the same related to the petitioner shall remain stayed till the next date. As the interim order of this court was not being implemented, the respondents filed a contempt application, which was disposed of, contempt application giving rise to CONTC number 1628 of 2017. The writ application and the contempt application were later disposed of with a liberty to the respondent to file a first representation. So stop. Next. It is when was he released?
Minute.
Or he released, when was the respondent released?
And 5/2018,
Minute.
relieve.
And relieved on same day.
The
High 7.
the said interim order continued till 22/2/2019.
And a first application was made on after after the transfer order 5/7/2017.
Mister, there was an interim order. That order continued
After
till
3 months, he has interim order was obtained in second application.
Yeah, the interim order continued till 22/2/2019.
She joined on 26th of May 2019.
After
Person to-
disposal.
Huh?
After disposal of WPC 21109/2017, along with contempt petition.
She was allowed to join.
She was reposted. They joined on 28/5/2019.
2019. Continue till 2019. The university allowed the respondent to join on 27/5/2019 because of the interim order. Because of the interim order.
Because of the final disposal of that writ petition.
Man, Annexure 12.
Our
she was-
order of transfer was modified. That is at page 52, my lord, of the writ appeal. The operating portion at page 53.
Annexure 12 of 54, page 54 may kindly see.
In view of the
55,
above,
page 55.
our representation is considered by the Honorable Vice Chancellor, and in partial modification of the office order number such and such dated 5/7/2017, she is hereby reposted against the vacant post of Associate Professor in the Department of Agronomy.
Where is
College-
that?
Page 53, my lord, of the writ appeal.
Yes.
She has joined. 28/5. Page 55 may kindly.
Upon considering her representation in the light of this court's order passed in WPC number and CONTC number, that order,
Yeah, 22 February 2019. The final order.
the operative part of the order passed by the Vice Chancellor dated, issued wide memo dated 6/8/8 dated 28/5/2019 reads thus, page 53 of the writ petition. Page 53 of the writ petition or
Writ appeal.
writ appeal? 53 of the writ appeal ka, in view of the above. Apparently thus, the order of transfer which was issued on 5/7/2017 was later modified by subsequent office order dated 18/5/2019.
28.
18/5/2019.
28/5.
28/5.
2019.
28
page
5, not
52,
18.
Annexure 11.
28/5. 28/5/2019. So stop. Next, learned counsel appearing on behalf of the university has argued that soon after the order dated 5/7/2017 was passed for transfer, he was relieved on 6/7/2017.
The same day.
On 5/7/2017.
Yes, yes, ma'am. 5/7.
An order to this effect was issued on the said date. Oh, stop. The submission so advanced on behalf of the appellant cannot be accepted for two reasons. So stop. Firstly, against the order of transfer, the respondent had made a representation which was directed to be considered by this court. By an order dated 28/5/2019, the order of transfer was modified. So stop. Had the respondent been relieved on 5/7/2017 itself, there was no question of modifying the order of transfer, which according to the appellant had already taken effect to. First off. Secondly, comma, we find that in the find from the order passed by impugned order of the learned single judge, comma, as has been noted above, that a specific stand was taken by learned counsel representing the university based on the instructions provided to him that the respondent was never relieved in terms of the order dated 5/7/2017. First off, the orders said to have been passed, relieving the respondent after her transfer, on which the university is now relying upon, was not brought on record before the learned single judge on affidavit. First off. Next, in the facts and circumstances of the case, we are not inclined to interfere with the impugned order, particularly in view of the fact that learned single judge exercising discretion under Article 226 of the Constitution of India has asked the university to pay 50% of the salary for the period in question, that is 4/11/2017 to 27/5/2019.
257,
257 to
25, 25/7,
25/7.
2019.
Oh,
27/5.
typographical error.
At the end of the judgment.
27/5/2000. 4/11/2017 to 27/5/2019. So we do not find any merit in the present appeal, which is accordingly dismissed. Yes.
Item number 2. Only one correction at the beginning. The instruction is dated 11/8/2023.
8/11.
11/8/2023.
11/8.
Yes, sir.
11/8.
The instruction.
8/11 है ना?
Hopeless.
Item number 2.
My lord. Yes. What is the judgment about?
Titulatananda, my lord, in that case, we are selected and one person placing below him was appointed earlier, my lord. And co-directed, he should be appointed from that date.
So therefore, we were putting this question.
Yes,
Now you appreciate that.
yes. Here, what happened, my quota is occupied by somebody else.
Occupied, that is different question. Therefore, we were repeatedly putting this question, that whether any person below in the merit.
Below or not, my.
Then what do you want?
Withdraw, my lord.
And counsel appearing on behalf of the appellant after some argument seeks permission to withdraw this appeal, which stands. This appeal stands disposed of and withdrawn.
Item number 3.
The petitioner challenged the order of the learned single judge matter, rejecting the prayer for interim release of my vehicle matter.
Interim release
Yes, my lord.
of vehicle.
Matter. I am the owner, registered owner of a vehicle matter,
Hmm.
bearing in number OR 16C 6419 matter. Your lord, you will kindly see annexure 1 page in the Contractual portion. An application for release of illegal seizure of Bolero vehicle bearing registered number OD 16C6419. My name is Inam Hussain Khan. I'm the registered owner of the vehicle, madam.
So when the matter is pending, how the court can
Madam,
that
yes,
the-
madam. Madam, the vehicle was, allegation is that, madam, the vehicle was.
Mr. Counsel, a criminal case is pending.
No, it is not a criminal case, madam. It is confiscation proceeding under 56 of the Orissa Forest Act, madam. My reading, madam, section 56. This it is a confiscation proceeding, madam. I am challenging the in the confiscation proceeding. I pray for interim release of my vehicle, madam, as per the decision of the Honorable Supreme Court, madam, relied on 2000 Supreme Court. Madam, in that case, madam, the vehicle was loaded with timber, madam. So what the Honorable Supreme Court has held, that we cannot shut our eyes so that the forest will destroy, and that will affect the human life. In that view of the matter, madam, the Supreme Court has said, if at all the interim release will be done,
You are
that
challenging,
bank guarantee is
you
a
are
must.
challenging order dated 1/2/2024.
Yes, madam. Annexure 1, madam. Annexure 1, running page
1/2/2024.
running page Annexure 1, the relevant page is 16, madam. Page 16. Page 16, madam.
What is the direction?
The Honorable Single Judge, madam, has
Para 6.
held.
Para 6, what is the direction?
Yes, that let the confiscation proceeding will be disposed of within 6 months. My vehicle is in seized, madam, on 23/2/2017, madam. 23 to 2023, during confiscation proceeding number 8 of 2023. And till now the trial has not begun, madam. And there was no candle leaf in the truck, madam, in the Bolero vehicle, madam. The forest officer, there are contradictory submission made by the forest officer. The SCF said in his counter affidavit that 8 quintals of candle leaf was there, but he cannot say the candle leaf was loaded in the vehicle, madam. And the SCF says, what the seizing authority, he says the vehicle was involved in helping in transporting candle leaves.
Yes,
Smugglers.
for this.
But there is no such authentic
Authority
proof,
will decide.
therefore, my prayer is, madam, I am ready to pay bank guarantee, madam. No, my vehicle is really intimate. So
Let
that otherwise I am earning my livelihood, madam. It is a taxi.
Mr.
Madam?
Direction is absolutely correct.
Yes, madam.
Asked by the learned single.
No, madam, no. But I am reading just the relevant portion of the Supreme Court, madam. Basing on the Supreme Court, the release of the vehicle is in Supreme Court was in against the vehicle.
Give.
Yes, madam. Madam, in this case, madam, log was transported.
Please give.
Yes, madam. I'm giving, madam.
You are arguing against yourself or in your favor?
In my favor. And in that case, my lord, Supreme Court was not in favor of releasing vehicle used in transporting logs, my lord.
So we
Cutting
are
logs.
relying on this.
Yes, for cutting logs, forest can destroy, forest is destroyed. But leaves are fallen and new leaves will come, my lord. This is a case, allegation of transporting leaves. But there was no question of transportation, my lord. Vehicle was there in a standing position.
No.
8 quintal candle leaf was there in the road. How can they connect my vehicle with that candle leaf, my lord? That is my assumption, my lord. They have not given the photograph. Even if assuming that candle leaf was loaded in the Bolero vehicle, they should have given a photograph of the vehicle. So that the honorable court has to hold easily that yes, candle leaf is there, I am not inclined. according to this matter. This specifically says the Supreme Court was not against the release of interim release of vehicle matter, but he was against the interim release of vehicle if the vehicle is loaded with locks. He has never said interim release of vehicle loaded with leaves matter. Leaves can fall. Another leaf will come. It will not destroy forest. Supreme Court is not in favor of destroying forest matter. How forest will destroy matter? By cutting logs. So in that case, my lord, logs was transported in a jeep. And when the Honorable Karnataka High Court has released the vehicle by submitting bonds only. But here, the Supreme Court says, if on exceptional grounds, even false allegation a vehicle is seized, the court has the authority to release the vehicle by using bank guarantee matter. I am in favor of giving bank guarantee, the new vehicle matter I have obtained from financing the bank for applying as a taxi. I am earning my livelihood. I am an unemployed graduate man. I have never been involved, I am categorically in my petition matter, I have never been involved in any of the forest offense in my life. I am a young man. No single offense has been instituted against me. In spite of that, my lord, if I will be in for another 6 months.
You were never caught earlier.
No, my lord, never, till now also no case here.
You could not be caught earlier, and thereafter.
I am not in favor of leaping casually, my lord. I am simply, my lord, some people are gathered.
So your client is a successful criminal.
No, my lord.
Maybe.
So far my knowledge goes, my lord, he was.
Why should your knowledge prevail? Your knowledge is.
Sorry, my lord, I have an instruction.
All right. In the present intra-court appeal, the appellant has put to challenge an order dated 1/2/2023 passed by a learned single judge of this court in WPC number 35293 of 2023. Stop. The petitioner's vehicle. What is the nature of the vehicle?
Bolero Power Plus, my lord. Bearing registered number ORC
vehicle, that is
6149.
petitioner's Bolero vehicle was seized by the forest officials for violation of the provisions under which act? Indian Forest Act?
56 Forest Act, my lord.
Huh?
56 of the Orissa Forest Act.
Odisha Forest Act. A confiscation proceeding has been initiated for confiscation of the vehicle by a competent authority, which is pending. The petitioner made an application. The petitioner filed this application seeking a direction to the divisional forest officer, Subarnpur Forest Division, for interim release of the vehicle during the pendency of confiscation proceeding. Then single judge, after having taken into account the pleadings on record and the submissions advanced on behalf of the appellant, reached a conclusion that it was not an exceptional circumstance which required issuance of a writ for interim release of the vehicle, taking into account the provision under section 56(3) of the Odisha Forest Act 1972. Odisha Forest Act. Which page?
230.
Madam, 56 2C is the relevant section, madam. 2C. Without prejudice to the provisions of section 2B, no order of confiscation under section 2A of any tool, rope, chain, boat, vehicle, or cattle shall be made if the owner thereof proves to the satisfaction of the authorized officer that it is used without the knowledge, connivance or knowledge or connivance of his agent, if any, for the person in charge of the tool, rope, train, boat, vehicle, etc., in committing the offense, and that each of them should
Under
be
the
taken.
proviso to section,
2A is the
proviso to
2A
subsection
is the
3
procedure, my lord.
of
2A.
section 56 of the Act. Stop. While declining to issue such a writ of mandamus, writ in the nature of mandamus, and single judge has directed by the impugned order, comma, the authorized officer, comma, assistant conservator of forest, Sambalpur Forest Division, to dispose of the case number
8.
8 of 2023-24 on sworn merits as expeditiously as possible,
For a period of 6 months, my lord.
preferably within 6 months. Stop. Learned counsel appearing on behalf of the appellant has, however, the appellant assailing the impugned order has relied on a Supreme Court's decision
2000 Supreme Court, my lord, K. Krishnan, my lord,
in
State of
case
Karnataka.
of State of Karnataka versus K. Krishnan, reported in 2000 volume 19 OCR bracketed SC 513. Stop. We have carefully perused the impugned order passed by the learned single judge and the decision, Supreme Court's decision on which the reliance has been placed. Stop. Placed by learned counsel for the appellant. Stop. It has been clearly laid down that generally, when any forest produce, tools, boats, vehicles, cattle, etc., used in commission of the forest offense, which are liable to forfeiture, are seized, should not be released. Stop. The Supreme Court further observed that further reiterated that when any vehicle is seized on the allegation that it was used for committing a forest offense, the same shall not normally be returned to a party till culmination of all the proceedings in respect of such offense, including confiscation proceedings, if any. Stop. It, however, observed that nonetheless, if for any exceptional reasons a court is inclined to release the vehicle during such pendency, furnishing a bank guarantee should be the minimum condition. Stop. Learned counsel for the appellant has submitted that the appellant is ready to furnish a bank guarantee for release of the vehicle. Stop. The question, as has been noted in the Supreme Court's decision, question of interim release of a vehicle alleged to be engaged in a
Transporting
forest
timber.
offense can be released on only exceptional circumstance. Stop. We do not find any legal infirmity in the impugned order passed by the learned single judge, as learned single judge found that there was no exceptional circumstance to issue a writ in the nature of mandamus directing interim release of the vehicle in question. Stop. The impugned order does not suffer from any legal infirmity requiring this court's interference. This appeal is accordingly dismissed. Yeah.
Yes. But when you say this, Page 27.
Hmm?
Page 27.
Just a page,
Page 27 of that. Writ appeal.
just 557.
Item number 4.
May I pray your lordship? Sir,
Have you prepared?
as per your direction, I have prepared the written note
So because we will see,
along with the documents.
we will all right. We will see and pass out. We will see your,
Sir, 2-3 lines I would like to say. Can I say?
we will note that also. Yes.
As yesterday I have spoken, I was bit ill, so I was not able to submit my case. But now today I can able to speak. So I would like to.
Today you have given us everything. So we will go through the file.
Yeah, sir. In brief, can I say 2-3 lines?
Yes, yes.
See,
Glad you can say.
Yeah. Sir, actually, this matter is related to the that total vacancy was 15, and out of that, 12 post has been recommended. 3 are still vacant. Out of 3, 1 post is reserved for me, since 1 year. And being a sports person as well as in the having highest API score, I have been reached from the screening to interview, and in the interview also I have also participated in the interview and did well, but it is a matter of surprise that I have not been recommended. Now I have gone through the case and find out that there are 94 candidates who has appeared along with me in the document verification, and out of 94 candidates we have shortlisted 75 candidates for the interview in 1:5 ratio, but and out of 75, 12 got recommended. But it is a matter of surprise that serial number 1, serial number 4, serial number 6, serial number 8, these are the candidates who have not participated with the interview process along with us, because in the document process I have given the material facts also annexed. I have annexed in 1, 2, 3, 4 in my written note of submission. So these people have not participated in the advertisement number 08/2020-21. They are having a different advertisement number 09/2021-22. So it is a matter of surprise that I am a sports person having a valid sports ICAD. I am not claiming for my, I cannot claim because advertisement there is no specific mention of the sports person. But people are having not participated in the document screening to document verification, but they are in the rank holder, top rank. So this is a discrimination and this is a prejudice towards a petitioner. In this regard, I have also submitted 2 identical case. So along with this written note of submission. This is and all the irregularities, all the
You
illegal.
have given us these papers. Your appeal.
This is the brief what I have written.
Your appeal is there, your writ petition is there.
Review.
There are 2 judges who will see your and take decision. All right.
Thank you so much, obliged.
But
Item number 5.
May I please your lordship and VC.
Item 5.
Direct me to find the reply to this, my explain reading. Way I will file it in course of the day. Possibly take it up next week, so that.
What is this about?
He said that construction of a road within a municipal area is being delayed, for which public are suffering a lot. Barampur Municipal Corporation area, he says that there is a busy road and the construction is going on for a longer time, for which the public are facing a lot of difficulties by through thoroughfare. That is his allegation.
How much time do you need?
No, it's ready only. I will file it through e-filing today only.
Tomorrow, wait for the petitioner.
Because he's
Oh, you joined.
Yes, sir. I will not receive the copy. I will copy of
You
the.
will get a copy. We will post the matter after 1 week. In the meanwhile, you will get a copy, and it is stated by Mr. Samantarayal and additional government advocate that pursuant to this court's order dated 19/3/2024, counter affidavit has been prepared and likely to be and shall be filed in course of the day. So, let a copy of the said counter affidavit be served on learned counsel for the petitioners. All right, you can send him. Do you have your email?
Yes, sir. I have my email. Yes, sir.
You share it with the.
Do you have your email ID?
If you have email ID, share it with learned AGA so that he can serve a copy.
Okay, sir. Okay.
Learned counsel for the petitioner shall be required to furnish his email ID, and petitioner who has joined online shall be required to furnish his email ID to learned AGA so as to facilitate learned AGA serve a copy of the counter affidavit upon him. Stop. List this matter on 1 week. What is your stand?
We have stated that it was, in fact, earlier it was by the municipality. Now the work has been handed over to Works Department. So Works Department carrying on, it will be, we have given a deadline, we'll do it.
Item number 6.
Item number 6, if I may please, your lordship. On last occasion, I'll just give an overview of the matter, your lordship. The annexure, the order passed by the learned collector under annexure 13 and the notice issued by the Sarpanch under annexure 14 is under challenge, your lordship. On last occasion, your lordship put forth a question with regards to under what provision of law the order under annexure 13 has been passed. The provision of law referred to is in section 15 of the Right to Fair Compensation Act, your lordship, wherein the collector is empowered to hear preliminary objection with regards to any land which is being intended to be acquired by the state, your lordship.
Which provision?
Section 15. Section 15, subsection 2. If I may place the subsection 2. Every objection under subsection 1 shall be made to the collector in writing, and the collector shall give the objector an opportunity of being heard in person or by any person authorized by him in this behalf or by any advocate and shall, after hearing all such objection and after making such further
So
inquiry.
this has nothing to do with the amount of compensation.
No, Your Lordship.
Yes.
The matter before Your Lordship is that the state is intending to acquire a piece of land measuring 415 acres in the district of Mayurbhanj, which comes under the 5th schedule area, Your Lordship. Under Annexure 2, the state has already prepared a feasibility report with regards to how much government land is there, which can be leased out to the opposite party number 9, Your Lordship, for setting
Opposite party number 9.
opposite number 10, that is Rungta Metals, for setting up a steel plant in that area. The whole objection of the petitioners is that under Section 4I of the Panchayat Extension to Schedule Area Act, the Gram Sabha has to be consulted prior to any motion set forth by the state for towards either acquisition or even proposal of the acquisition of that land. So once the news of setting up the plant by opposite party number 10 was publicized in the local newspaper in Mayurbhanj, and after getting the RTI report under Annexure 3, the petitioners made a representation to the collector objecting to the said intention of acquisition of land in the said area. So also convened a Gram Sabha meeting, and the decision taken in the Gram Sabha meeting was also communicated to the collector, Your Lordship. On first instance, the collector sat over the matter, did not take any action. Hence, the petitioners appeared before this honorable court in writ petition number 5695 of 2023, wherein a direction was issued by this honorable court for consideration of the said representation. After the said representation was considered.
Mr. Counsel, this is a statutory order. After this order, you approach this court.
The order under Annexure 13, Your Lordship. Yes, Your Lordship.
So that order could not have been passed because that order, without quashing the order, there was no question of asking for representation because it's statutory order.
Yes, Your Lordship. I'm coming to that aspect.
Yes.
The statute, I'm just giving a brief overview, then I'll come to the Annexure 13, Your Lordship. Under Annexure 11, the collector considered the representation and passed a previous order, wherein it stated that the Pesha Act is the Panchayat Extension to Schedule Area Act is not applicable to the district of Mayurbhanj. Against that order, also the petitioner approached this honorable court in WPC number 25998 of 2023. After approaching this honorable court, the collector withdrew that order, stating that the said order is erroneous and is not maintainable. And again, the matter was remanded back to the collector. After the matter was remanded back, the Annexure 13 order has been passed. Now that order may be seen, Your Lordship. It is page 114, Your Lordship.
Yeah.
The submissions have been recorded in page 115. And the operating portion or the findings has been given under page 116. I'll first take, Your Lordship, through the submissions made and then the findings. The submission starts from para 1 of the page 115, where the paragraph has been numbered, Your Lordship. The submission of the petitioner is that being aggrieved by the order dated such and such, they had approached the Honorable High Court in petition number such and such, praying for setting aside the same. It is submitted that the Honorable High Court by order dated 2012-2023 has remitted the matter to this court for reconsideration of the representation made by the Anandapur Pesha Gram Sabha, wherein the villages, by convening a Gram Sabha under Pesha Act, has made their intention clear. With regards to the setting up of the plant of Rungta Metals Private Limited, it is submitted that the district of Mayurbhanj, being a 5th schedule area, is covered under the provision of the Pesha Act. Citing the following extract, the extract has been cited. It is submitted that Act specifically provides that the state, before initiating any developmental work, project or any acquisition of the land shall first consult the Gram Sabha, and after getting their consent, we said the project should be taken ahead at appropriate level. The section 4I has been quoted below, Your Lordship. It is further submitted that the apex court in such and such case has clearly given the emphasis on conducting a Gram Sabha convened by the district judge so as to get the consent of the villagers with regards to the intended developmental work in order to avoid any coercion, manipulation or pressure applied by the state and its machineries/officers on the innocent villagers. It is submitted that the aforementioned view of the Honorable Supreme Court has mandated the consultation with the Gram Sabha of the villages situated within the 5th schedule area and has become a sine qua non for any developmental work to be carried out within the area under the purview of the PESA Act. It is further submitted that in the interest of justice and in the case at hand, it is essential that a Gram Sabha be conducted in the village of Anandapur in the presence of District Judge Mayurbhanj at Baripada so as to follow the provisions of the PESA Act, as well as to ensure the state machineries are working in accordance to the guidelines given by the Honorable Apex Court. The findings, Your Lordship, has been given in a cryptic manner without assigning any reason. In fact, resolution was passed unanimously by the Purnapani Gram Panchayat on 10/3/2023, granting its approval for establishment of the industry by Rungta Metals, consisting of the villages of the Anandapur, Dandbos and Kontavani. These 3 villages are being affected by the intended project, Your Lordship. Under the Rajrangpur block, this constitute compliance with the provision of 4I of the PESA Act cited by the petitioners. Whereas my allegation is that, or the petitioner's allegation is that such a resolution was never passed, Your Lordship, unanimously.
So that is a question of fact.
That is a question of fact, Your Lordship. The so-called Gram Sabha under claim of the petitioners have not been conducted by following due procedure of law of the statutory provision of law. Hence, fresh Gram Sabha is to be conducted following due procedure of under the statutory provision of Act. Hence, he ordered for convening a fresh Gram Sabha, Your Lordship. So my submissions are on 2 folds. First is the submission made that the Gram Sabha be conducted by it being presided by the District Judge Mayurbhanj was never been considered, Your Lordship. Even if for argument's sake, let us assume that the order passed by the collector is right, Your Lordship. But subsequently in Annexure 14, I may be pardoned, the notice is in Odia, but the Sarpanch has called for a Panchayat meeting and not for a Gram Sabha meeting of all the villages that is being affected, Your Lordship. But the matter of fact is that
You are resident of which village?
I am the resident of Anandapur village.
Anandapur village.
Yes, Your Lordship.
So there was no Gram Sabha.
No Gram Sabha, Your Lordship. Rather, what my anxiety before this court is that, Your Lordship, a Gram Panchayat meeting.
Purnapani Gram Panchayat constitutes these 3.
No, Your Lordship, it constitutes 15 villages. Out of those 15 villages, including this.
Anandpur also falls within
this.
Kontavani, Anandpur and Danbos.
Danbos. So my anxiety before this court, why I filed it before the convening of this meeting was that because the Panchayat meeting is being conducted.
The notice says Purnapani Gram Panchayat, it invites all villages.
All villages.
To participate.
Yes, Your Lordship.
Right.
All villages under the Purnapani Gram Panchayat.
So that Purnapani Gram Panchayat includes these 3, including this Anand.
Yes, Your Lordship. But the issue.
But in the
So
last
your
portion,
village is not excluded.
My village is not excluded. What my premonition was that in guise of this Panchayat meeting, what will happen? The main objection is being coming from this Anandapur village. So by passing the said order in majority, by including the villages which are not being affected by the intended area.
But here, धार्य तारीख समय और स्थान रे उपस्थित हुई उक्त ग्राम सभा को.
But
So
this
is a Gram Sabha meeting.
But this notice was issued to all the villages under the Panchayat, Purnapani Gram Panchayat, Your Lordship, which consists of 15 villages. The issue which took place on
ଆଲୋଚ୍ୟ ବିଷୟ agenda is ପୁରୁଣା ପାଣି ଗ୍ରାମ ପଞ୍ଚାୟତ ର କଣ୍ଟାବାଣୀ ଆନନ୍ଦପୁର and Dandbush.
again, Rajaswa Gramara,
Rajaswa Grama, revenue villages.
Okay.
These 3 revenue villages
Ru-
matter shall be discussed
yes, Your
in
Lordship.
this Gram Sabha.
Yes, Your
That is the notice.
What happened, what transpired on 2nd March 2023 or 2024, Your Lordship, was that n number of imposters were present at the Panchayat office, because of which the villages of these 3 villages, along with the villages which comes under the Purnapani Gram Panchayat, they protested, Your Lordship, that such imposters should not be allowed to come to the Gram Sabha meeting or the Panchayat meeting, wherein without any resolution, the signatures and LTIs on blank paper were being taken, Your Lordship. It was a very highlighted matter in the month of March, properly covered by all the local news channels, Your
Mr.
Lordship.
Counsel, please don't make those submissions. We go by law and the materials on record.
I humbly apologize, Your Lordship. But such imposters were there, Your Lordship. So my humble submission before this court is that my prayer is on 2 folds, Your Lordship.
So you are relying on which provision of this PESA?
PESA, Your Lordship, I made a representation under section 4I stating that the
Where is 4I?
Section 4 states that notwithstanding anything contained under Part 9 of the Constitution, the legislature of a state shall not make any law under that part which is inconsistent with any of the following features, Your Lordship. Wherein 4I makes it an absolute right that the Gram Sabha or the Panchayats at appropriate level shall be consulted before making the acquisition of land in the scheduled areas for development projects and before resettling or rehabilitating person affected by such projects in the scheduled area. The actual planning and implementation of the projects in the scheduled area shall be coordinated at the state level. So hence, the definition of Gram Sabha, Your Lordship, has been given under Article 243 of the Constitution of India. (243B), Your Lordship. Gram Sabha means a body consisting of persons registered in the electoral rolls relating to a village comprised within the area of Panchayat at the village level.
What is the stage? What is the stage of acquisition?
On the present position, Your Lordship, is that on 2nd March, an unsuccessful Panchayat meeting was held. So right now, because of the
What is the stage of acquisition?
state of acquisition, Your Lordship, the demarcation proceeding has been carried out. The land which are under the government or recorded under the government has been identified. So also the private land which would be acquired for the intended project, that also has been identified.
Yes.
So let's see. By order.
No, the only question is that whether Gram Sabha was consulted or not.
Yes.
Where is the?
Yes, according to annexure, your lordship may see annexure 14.
Annexure 14.
Yes, my lord. This is the notice for conducting Gram Sabha on 2nd March 2023. This writ petition is filed thereafter. And he is saying that this, I have to take instruction what happened on this, because according to the notice, the Gram Sabha is already completed. 2nd March was the date. So what he is
Find
saying.
your affidavit, we will see. You are required to satisfy
Yes, ma'am.
that before you undertook, or when we can see how that provision can be read, that the Gram Sabha within the meaning of Article 243 was concerned.
Yes.
All right. For that, you must have issued notices to them. And whether Gram Sabha was held or not will depend on how the panchayats responded to your request. You seek instructions by your affidavit. Claim that they belong to scheduled tribes recognized under law and are residents of village Anandpur of Purusan Pani,
Puruna Pani.
Puruna Pani Gram Panchayat, the district of Mayurbhanj. Stop. It is the petitioner's case, post office, that the said area is a scheduled within the meaning of clause 1 of Article 244 of the Constitution. So, in the said area, 414 acres of land is proposed to be acquired for establishing a steel plant. So, it is the case of the petitioners that the mandatory requirement under section 4 bracketed I of the provisions of panchayats, bracketed extension to schedule areas, bracket closed Act, 1996, has not been complied with in as much as Gram Sabha has, it doesn't say Gram Sabha, it says Panchayats also.
The wording, your lordship, in the said act is that the Gram Sabha or the panchayats at appropriate level shall be consulted, your lordship. So for elucidation, if a project like a dam, which has a reservoir, which affects multiple panchayats.
That is very difficult. Gram Sabha, we were under the impression that Gram Sabha was not consulted within the meaning of the Article 243. It is not that Gram Sabha, only Gram Panchayat. What is the meaning of Panchayat?
The panchayat, your lordship, constitute of, as per the notification of the
Panchayat, in the Mukhya, the Sarpanch, they may be consulted. They may agree.
But my argument to this section or to my interpretation of this section.
No. Let us see. Gram Sabha / Panchayat at appropriate level. Gram Sabhas and Panchayats at appropriate level of the area have not been consulted. Stop. We, in the present writ application, in the nature of public interest litigation, the petitioners have put to challenge an order passed by the collector Mayurbhanj, wherein, on an objection raised with reference to section 4(I) of PESA Act, the collector has rejected the objection with the following findings. Page 116, findings of the portion. Next. Learned counsel appearing on behalf of the petitioners has, however, submitted that the said findings are cryptic and do not disclose as to whether the Gram Sabha / Panchayats were in fact so what is wrong in the order?
It's clearly written.
So he directs that Gram Sabha is
Gram Sabha is to be conducted. But the Sabha, your lordship, what my interpretation is that Sabha should be conducted in the village of Anandapur, Kontabani and Danbos, not a panchayat meeting at the level of panchayat.
Sorry.
My lord,
Sorry.
the whole panchayat consists of 15 villages. The resolution will pass in majority by the villages which are not being affected by the plant, your lordship, the intended plant. So also the area which is being acquired here.
Said order passed by, sorry, we will not interrupt. The said order is being assailed in the cryptic. Stop. He further submits that in terms of the said finding recorded by the collector, it is incumbent that Gram Sabha of these three villages,
Yes, Your Lordship.
of the three villages, namely
Anandapur, Kantabani, Dandabos.
should be
Purunapani, Gram Panchayat.
the meeting of Gram Sabha of these three villages should be convened separately and not and such Gram Sabhas should not consist of the entire Gram Panchayat. This is your submission
Yes, Your Lordship.
All the villages,
My,
all the villages of that.
of Panchayat, all the villages of
Purunapani, Gram.
that Panchayat together. This is your submission.
my alternative prayer is, Your Lordship, the Gram Sabha may be conducted, I have no issue. But it may be conducted in presence of the district judge Mayurbhanj so as to. If,
We cannot write constitution. We cannot. amend
Your
it.
Lordship, they said this Apex
Yes,
Code has
sir.
had directed in the case of Niyamgiri.
Then the Apex Court may direct.
That is my second submission, Your Lordship. My alternative prayer.
Under Article 243 bracketed B of the Constitution of India, which reads as under. Stop. The impugned order passed by the collector dated 11/1/2024, comma, the same must be held within what? In under the supervision of
The district judge Mayurbhanj.
District Judge Mayurbhanj. Stop. Next, we outright reject the prayer of the petitioners for holding meeting of Gram Sabha in Gram Sabha of the villages in the under the supervision of respective of the concerned district judge, as we do not find any material on record, do not find any controversy of such nature requiring issuance of any such direction. So stop. From the impugned order, we find that the collector Mayurbhanj, in all fairness, has reached a conclusion that Gram Sabhas have not been, meetings of the Gram Sabha have not been held. This is what he has held.
Yes, yes. Order is at page, next page.
And
One.
accordingly, he has
Order.
issued a direction,
Convene press. Conference.
issued following direction, page 117. In view of the above, so and so. Paragraph 1. 117 का paragraph 1. We have no reason at this juncture to presume that the Gram Sabha to be held under the order of the collector, meeting of Gram Sabha to be held in the under the order of meeting of the Gram Sabha. Gram Sabha is meeting. Gram Sabha itself is a
Is a
meeting.
meeting.
Itself is.
क्या लिखे? नहीं, to presume that Gram Sabha shall be convened not in accordance with the requirement of section of Article 243 bracketed B of the Constitution of India. Stop. Do you want us to interpret this provision?
No, Your Lordship, because everything is complied, Your Lordship can.
Gram Sabha, it appears prima facie, of course, to us, he is correct that Gram Sabha is of a village.
And that panchayat has to, the sarpanch of the panchayat is the mukhya of that panchayat. He has to convene the meeting. That is why he has issued the notice, Annex 14. But
No.
the the agenda is very specific. What Your Lordship, my Lord, has read out, that agenda is very specific. Only 3 villages that establishment of plant is to be considered.
3 villages.
Yes, that agenda Your Lordship can.
So, but 3 villages separately.
That is within that panchayat. That is why the panchayat head has convened the meeting.
No,
that,
please read sub B of 243. So a Gram Sabha cannot go beyond a village.
Mr. Mahanti, I have not said that. The agenda is something,
yes.
but he has invited all the Gramabasi, all the
Yes.
villagers,
But yes.
all the villagers of that Purunapani Gram Panchayat.
Yes.
The agenda is to discuss
Discuss.
in the Gram Sabha with respect to these
3 villages.
the establishment of this private limited
Yes.
by acquiring land of these 3 villages
Yes.
within the Purunapani Gram Panchayat.
Yes.
That is what the agenda is.
That is the agenda.
But he has
Invited
invited all the Gramabasis,
That is
villagers
there.
of entire of that
Purunapani.
entire gram.
So what he is, please see, definition is very clear.
Yes.
And it is not very difficult to hold Gram Sabha. Because in one village, how many electors may be there?
My lord, sir, there is a sarpanch in the Gram Panchayat.
There is no question of sarpanch. This sarpanch has nothing to do here. Of course, if you may take a plea that Gram Sabha is not to be consulted, Panchayat is sufficient.
Yes, Panchayat is.
That's a different matter. But see, if once you have decided that you will convene Gram Sabha, then you should convene Gram Sabha in accordance with the definition. And it is not a big exercise. So when you are doing it, you do that in accordance with law so that there is no scope of any interpretation further. It's very clear.
A village.
A village, yes.
A village.
Gram Sabha means a body consisting of a persons registered in the electoral roll relating to a village. Comprised within the area of Panchayat at the village level.
So confining that village only.
So you can have 3 meetings. This collector can direct the Sarpanch Panchayat, which Mukhya or whosoever, that he should have separate meetings. And please keep in mind that this is consultation only. Even if they take a decision that this should not be done, even then you have that authority to go for acquisition.
That is not
Not a very complex thing. But if we are required to interpret, we will have to. If you do something contrary to constitution, we will have to interfere.
And it is correct so far as.
No, we are just supposing it all. There is nothing. Stop. The no interference is required at present. So stop. This writ application stands disposed of accordingly.
Here, my lord, I have filed the writ application, my lord. This, the honorable single judge considered it to be a PIL. So accordingly, it has come before your lordship, my lord. My lord, your lordship will find, my lord, this PMAY, my lord, scheme, Grameen scheme has been introduced by the government of India to provide Pakka houses for the, my lord, needy people, those are the beneficiaries who are to be selected by the nodal agency, and thereafter funds will be released in phased manner, and proper implementation of the scheme has to be looked into by the authorities. Now, if your lordship will kindly turn to the, my lord, I am the, my lord, member of the Gramya Unnayana Samiti, my lord. My lord, I made a complaint that there are several irregularities in the, my lord, the funding of the under the scheme, my lord, and there has been lots of encroachment. The my lord, lands which are actually allocated for the purpose of construction, the constructions have been made, my lord, in government lands, encroaching government lands, and my lord, the funds have been released even though, my lord, the construction is not completed. So these are the irregularities and misappropriations.
First irregularity is that they have encroached upon the
government land. The second is, my lord, that the houses are not completed, but funds have been released. And now the beneficiaries, they are suffering, my lord. They are not getting the houses, my lord, in proper state as provided under the scheme, my lord. Now, on the basis of my complaint,
according to you, funds have been released, but the houses have not been constructed.
Not completed, my lord.
Which one?
My lord, I made a complaint before the collector on the basis.
House has not been completed?
That is there, my lord. I will take your lordship, my lord, to the inquiry report, my lord. That is at page 20. My lord, I made a complaint before the collector. Collector constituted a committee. The committee conducted an inquiry. Now, your lordship may kindly come to page 20. In page 20, your lordship will find one Kumuti second one, my lord. One Kumti Kshatriya, he, my lord, he has constructed the house not over the land which was allocated for the purpose, but he has constructed the house on the land of his uncle, my lord. My lord, the next, my lord, that Samuru Kheti, he has constructed the house over a government land by encroaching a government land.
So what should we do?
My lord, now unless this is, my lord, properly inquired into and the collector inquiry has been made, but no further action is being taken, my lord, by the collector to find out who are the actual instrumental to these irregularities, my lord. The collector is not taking any interest over the matter.
Instrumental are they, the people who have received funds?
Those have received fund. Your lordship will find one Surubali Jagat, who is a widow. My lord, her house is at plinth level, but the entire fund has been released and the contractor has misappropriated the entire money. Now, my lord, she is a widow. She is not getting the house, my lord. These are all irregularities. They have conducted just, my lord, some inquiry on pick and choose basis, my lord.
Who has to construct the house?
My lord, the contractors. The agency provides a contractor, my lord, to construct the house. Now they are, my lord, misappropriating the entire fund, and the people, those are the beneficiaries. They are not getting
give us the name of that lady.
That lady, your lordship will find page 21, last one, Surubali Jagat. Your lordship will find her house. She is a widow. Her house is at plinth level. The entire 4 installment have been paid to in her account. Then your lordship will find, my lord,
therefore the amount has not been paid to the contractor. The amount has been deposited in her account.
But the contractor executes the work, my lord.
How do you say this? The amount has been deposited in her account.
Or in her account, but the contractor who my lord, undertakes the works, my lord,
How
they
do
are
you say-
withdrawing the money from her, my lord, because they are the
This is-
innocent villagers, my lord.
The such submissions we cannot accept.
And
We were under the impression that the work was given to someone and who he did
You-
not construct.
in
And
that respect, your lordship will find one Radheshyam Bhue.
yes,
Your lordship will find, however, the house is not completed and roof is made of asbestos sheet. On inquiry, the beneficiary told that he had assigned the work to some contractor and he had withdrawn all money but not completed the house.
so he's a crime. File complaint case. File a criminal case against him.
My lord,
Come to the High
my
Court.
lord, the nodal agency has to see, my lord, proper implementation of the work.
This amounts to misuse of the process of the court. You know the law. If someone misappropriates money, there is a criminal law. That's a criminal offense. You can file a criminal case.
No, that is in respect of one, my lord. But
respect of- You can file 100 complaints.
but
You are coming to the High Court.
enforcement of the government land, other things, my lord, and the funds have been released without verifying whether the work has been completed or not, because your lordship sees, my lord, in
All right.
4 phases, the amount has to be, my lord, released.
All right.
Now, first phase is to be released on plinth level. Then second, roof casting. After the roof casting, the second phase will be.
Council, we put a very simple question.
Yes.
What orders should we pass?
My lord, my only grievance is, my lord, your lordship
Forget
may direct the
grievance. You have
collector.
come to the High Court.
Yes, my lord.
Please tell us, what order do you need from the High Court?
My lord, the order I need, my lord, your lordship and direct the collector to, my lord, take action against the persons who are instrumental to this, because it has got a
It's
far-reaching consequence. my lord.
very easy for us to do. We will do it. As directed by you, we will pass the order.
No, not directed
Yes,
by
sir.
me, my lord.
Yes, it's
I
very-
can only make a
see,
prayer,
Mr.
my lord.
Mr. Counsel, please appreciate you are a member of very important profession.
Yes, I understand that.
So when you come to this court, you must keep in mind that the system is overburdened. And you must be clear as to what are our limitations, whether can we run the government?
No.
Can we become the officer in charge of a police station? Can we become circle officer? Can we become collectors? So if there are what is 406 of the IPC?
That is there.
What is 406?
406 is, my lord,
It's a criminal breach of
criminal
trust.
breach of.
Can we issue a direction that there should be no offense, no person shall be allowed to commit that offense? Can we issue?
No, that your lordship cannot issue. But
Therefore, if you seek a direction that we should ask them to take steps in accordance with law, it's a very easy thing. All the writ petitions can be disposed of this way. There must be. Therefore, when you said that a particular lady, her house was half built and the amount was misappropriated, yes, we became sensitive about that. We would have taken action. But the amount has been deposited in her account.
in her account, but
Now you are saying that that amount has been taken by someone else. That's a matter of inquiry.
but the nodal agency, why I am
See,
submitting, my lord.
if you have so much interest in public interest, then you can go to them to help them to ensure that they get the houses under PMYG.
That is
Not
that is
this
what
that
my
you put action inquiry, he will also do some inquiry, he will also pass some order.
my entire effort is that, my lord.
Your effort is appreciable, but not in
But,
proper direction.
But unless this is checked at this stage, my lord, it will have a far-reaching consequence, my lord. The nodal agency is
Murder
there.
has been checked.
Well,
Murder has been checked.
no, my lord, that-
Rape has been checked. So when you say that it's check, of course, let us make an attempt. You also,
Yes.
the court also, the authorities also, all of them should make an attempt. All right, let's see what order can be issued.
The direction to the collector will solve the issue, I think. But
The-
because nodal agency is
Rajan.
there, we are there.
Writ application has been filed raising grievance regarding misuse and misappropriation of public money in the name of providing funds for construction of Pradhan Mantri Awas Yojana. Stop. Next. Learned counsel appearing on behalf of the petitioner has extensively argued and referred to the nature of irregularities which are prevalent in implementation of the said scheme. Pradhan Mantri Yojana bracketed Gramin. First off, he has drawn our attention to an inquiry report of whose
My lord, this is by a committee, my lord. Committee consisting of, my lord,
Annexure 3.
Annexure 3, my lord, page 20.
Submitted by additional video.
Yes, my lord.
Of a committee relating to such irregularity, report of a committee which discloses certain irregularities in implementation of the said scheme, which has been brought on record by way of Annexure 3 to the writ application. First off, he submits that it is manifest from the said report that the beneficiaries are not getting the advantage of Pradhan Mantri PMY, Pradhan Mantri Gramin Yojana. Pradhan Mantri, what is that? Pradhan Mantri Housing Scheme.
Pradhan Mantri Awas Yojana,
Pradhan Mantri
Gramin.
Awas Yojana, bracketed Gramin. And some middlemen are duping them. Full stop. Next. Considering the facts needed in the writ petition and the submissions advanced on behalf of the petitioner, we dispose of this writ application with an observation that the collector, which district?
Collector, my lord, Subarnapur.
Subarnapur.
Collector Subarnapur is expected to look into the findings of the report bracketed Annexure 3 and take necessary steps in accordance with law. Application stands.
Item number 8.
Wait, please, Your Honor.
May I, not item 8.
The tender matter yesterday.
Matter was listed before the Lordship. Today itself, the copy has been sought on me.
No, I served a copy on the government and today actually Your Lordship directed
Yesterday we
to appear
proposed.
today, so I served a
Yesterday we
copy.
proposed
Right.
to serve a copy on.
Yes, copy served already.
His
No, this is a matter Your
representative
Lordship knows
Let
that.
him go through it.
But
Let him
here,
at least go through it, then
right,
only then he can make his submission. That much.
day after tomorrow, if
Day after tomorrow, yes. As requested on behalf of the state. This matter on Thursday.
You are appearing on behalf of opposite part number 3.
3.
No. Unless we are satisfied, the moment we are satisfied that yes, there is something, then only we will issue notice to the private party.
Absolutely. Well, your lordship heard it yesterday, but I have already paid the amount, but still then they discarded it on a flimsy ground. And I have already paid the amount. They say the GST amount has not been paid. But at the end of the month, actually, GST is calculated. I deposited the next day. But the question is not required. I have paid. The e-portal says these are the amount you have to pay. E-portal cannot accept 1 rupee extra. It will not accept. So entire they have successfully paid. So yes, it can be a curable defect. Worst case, you can reject that amount. Interestingly, with due respect, permission. But there are 3 bidders. Bid process, they are not into 2 bidders. But they say that there should not be any litigation pending against any one of the litigation there previously also last 10 years. But any company, Tata, Birla, or any big company who has does work without arbitration case.
That is not the qualification criteria.
Yes, that is there.
But the bidder should produce that.
No, you cannot. You say it will eligibility criteria.
No.
We will see. Please examine that aspect. If that is there, we will strike that down.
Right. The 2008 Supreme Court is unequal bargaining power, and also that levels the doctrine of level playing field. You cannot discard somebody with a group of persons and select somebody with the aim to give somebody else. 1-2 years experience, no litigation. But your long-standing contractual
only to disclose. But that only to disclose that. What are the litigations are pending? But that is not a bar for.
We have disclosed.
Item 9.
On behalf of Mr. Dole, one passo.
As requested on behalf of the petitioner, is this matter on? Is this PIL? PIL. What is this about?
Endowment. Endowment.
Not PIL. As requested on behalf of the petitioner, is this matter on 2 weeks?
Item 11. Sorry, item number 10. Item 10.
Item 10. Lordship, this is an identical matter, a contract teacher matter. All matters are posted to 24th April, Lordship. Kindly tag.
Validity of Rule 4
Yes,
of the repeal.
yes, ma'am.
That is
2022 to 24.
Item 11.
Obliged.
So my immense pleasure to place the matter before your lordships about the grievance of Cuttack City. Cuttack City I will take 1 minute about the history of the embankment. Cuttack was the capital city of the ancient Orissa. At that time, there was no embankment all around, but the floods are entering to the city every year, 3 times, in say monsoon, return monsoon, and low pressure rain. At that time, the entire city used to be merged like a pond with the dirty mud rainwater. At that time, no relief system was there, no well, no pipe water.
But now the system has improved.
Yes, my lord. I'm telling about that time. Also, a small instant how the pond water and well water was used to be dirty, and after the rain flood is gone, people used to be suffering from health hazards. Mahamari used to come there. One day at that time, Markata Kesari was the king. He was coming on the main road. One old man come to the road and asked that I want to meet the king. She was not allowed. Seeing the situation, the Maharaj told, who is that person? Then bring him to him. When he went them, he told that why you are.
You are one of the petitioners.
I am coming.
You are one of the petitioners.
No, yes, I am the one of the petitioner and also a lawyer.
You remove your ban.
Pardon?
You remove your ban and.
I'm
Not here, madam. Outside the court. Not here.
Okay. बाहर करके ऐसी छेड़ो.
Tomorrow? Tomorrow.
Just a minute, my lord. With that, I was wasting 1 day.
Not even a second. Tomorrow, you cannot argue in your own case
With
your
ropes.
ban on. Tomorrow.
Item 12.
Maybe the law. And the petitioner pressed for that the opposite parties have not displayed the petitioner's institute, which is a industrial training institute in the state scholarship portal, for which the petitioners have not applied for the scholarship to prosecute their studies in the industrial training institute, my lord. The students who are the post-matric students have applied through the government portal, my lord, to admit in the industrial training institutes, and according to the government portal system, online system, my lord, they have been selected and admitted in the petition, that is the global ITC, Raulkela, to continue their study in the trade of fitter and electrician. And they are continuing the study only through the, that is by the finance by the state scheduled caste scholarship. The students are scheduled caste students, they are only depending on the scholarships, which have been given by the state government, my lord.
What do you want?
My lord, the state government has not displayed the names of the petitioners institute, which is a private industrial training institute, in the state scholarship portal, for which the petitioners will apply for scholarship and to continue their study in the industrial training institute. The college has already fulfilled all the criteria to get scholarship from the state government. And the students who have been appointed, who have been,
So your institution runs on the basis of scholarship?
my lord, that is the annexure 4, my lord. Previous years, the second year students have already got the scholarships. But the
So
now,
if the government withdraws that scheme, then what will happen to your institution?
my lord, government has not, government has already sanctioned to the private, all the private institutes, but the
So
present
you have opened this institute because of that scholarship, or?
only scholarship, my lord.
Huh?
Due to non-availability in the state scholarship portal, the petition cannot apply for the scholarship. If the state government will allow that,
No, you will not get any benefit. The scholarship will not be given to you.
given to the present person are the scheduled type persons, the scheduled two students, my lord. They are eligible
No,
for
no, whether you are an institution or whether you are an institute or student.
students, my lord. I'm the
You are a student.
students, my lord.
All right. You are studying in this global Rautkela global ITC.
My lord, fitter and electrician they are continuing, my lord.
Huh?
Study. The petition is continuing their study in the fitter and electrician trade, my lord.
So global ITC asked you to file this petition.
My lord, they are the last year they have also got
Yes. What is the position?
In the interception, this is the government has this policy of.
All right. 8 weeks time is allowed for the estate to file counter affidavit. Let's this case on 8 weeks. You have the copy?
Yes.
My short period, my lord, date will be short period, my lord.
Why? Let it come.
My lord.
Item number 13.
Obliged, my lord.
Chapter number 13, all the orders have been complied with, Lord.
Yes, it is
I've given a copy to my friend also, Lord, so.
stated by orders complied with, madam.
Yeah, everything is
It
complete.
has been stated at the bar that the orders of the court, violation of which has been alleged in the present batch of contempt applications has been complied with. These applications stand disposed of accordingly.
Item number 14.
14 also, Lords. I've complied the file compliance affidavit. Where I've stated that you are entitled to rupees plus 30.
No, but he is happy.
No, I am filing a reply to the object, the compliance affidavit, my lords. That they have not complied the affidavit, they have not fully complied the affidavit,
Let us see.
my lords. That is my affidavit, my lords.
Just, where is the order?
The order, my lords, that is annexure, my lords, annexure 2 of the order.
No.
Fleet application annexure 2 at page 24, my lords.
Yes. What is the order?
That is, my lord, that is paragraph number 6, my lords.
Yes.
All retiral benefits due to the appellant be reworked on the basis of the present judgment and be released to him at the earliest and in every event not later than 8 weeks from today. The short fact is, my lord, the petitioner was appointed as a professor. His appointment, assistant professor, his appointment was under challenge. Subsequently, my lords, that was dismissed, and subsequently I filed a writ appeal. And during the writ appeal, my lords, I was retired from the service. So from 1994 to 1992 to 2022, I was continuing as assistant professor. There was no promotion. There was no promotion was given to me because during the pendency of the writ appeal, my lords. After I was retired from the service in the year 2022. After that, a writ appeal was came and the writ appeal was disposed of as I was retired from the service and directed the reworked the retirable benefits, my lords. But they have given a compliance affidavit. Then, my lords, I filed a contempt application, and they filed a compliance affidavit, my lords, only pointing out that that is at annexure, my lords, annexure 1, A by 1, that your unutilized leave salary so and so, amount, gratuity amount so and so, and area amount so and so. I filed an objection, my lords, that is at paragraph number 4, my lords, that as per the Gratuity Act, my lord, payment of Gratuity Act, that gratuity amount will be calculated, my lords. That is
no, whether there is any discussion on the point of gratuity.
No, there is no discussion. They have given only abstract manner.
No, in the order.
That is all retiral dues, my lords.
Oral retiral due, they might have. There is no direction that this much of gratuity amount is to be paid.
Because, my lord, that is Valmi, my lord, there is no pension. They will only get, my lord, that is only gratuity.
So therefore,
gratuity unutilized salary.
The court just directed to rework the retiral benefit.
Yes.
According to, they have reworked, and according to them, what you are entitled to has been paid.
Yes, that.
If you have any grievance that something has not been paid, which you are required to be paid, you can take steps further. There has to be a specific direction.
Yes.
If any case of contempt is.
Just 1 minute. The retiral benefits, my lords, as per the Valmi, my lords, that is the autonomous organization, my lords, that is they will only pay, my lords, that is gratuity, unutilized leave salary, and my lords, differential allowance, nothing else, my lords. And
Mr. Just think of a situation that while complying with the order, they mention that you are not entitled for any earned leave. Whether this will amount to contempt or not.
No, yes, that is the amount to contempt.
That will not amount to contempt because that decision may be illegal. Compliance is there.
Yes.
But had there been a direction that you consider his earned leave and decided, the matter would have been different.
That is that what is my reworked, my lords. That is, if I have retired, my lords, I will retire, I will get some financial benefit, no work, my lords. Then the what is reworked? Rework means
willful disobedience.
Willful disobedience. See, the contempt is a quasi-criminal proceeding.
Yes, my lords.
In quasi-criminal proceeding, the offense should be clear. Unless the offense is clear, we cannot proceed. So it has its own limitation, contempt proceeding. Therefore, so we will give you liberty. We will give you liberty to question their decision. It is in the present contempt application, the petitioner has alleged disobedience of an order passed by a coordinate bench of this court dated 29/2022 in WA number 18 of 2015, operative portion of which reads thus, paragraph 6. It is the stand of on behalf of the estate that the retiral benefits due to the petitioner has been reworked in terms of this court's order dated 29/2022, and payments have been made against which head? Which head?
The payment has been made on the head of unutilized leave salary,
Against
gratuity and arrear salary.
unutilized leave salary. Let's put it over, salary equivalent to unutilized leave, comma, gratuity and
arrear salary, 3 heads, no.
and
Arrear salary. Arrear salary.
and arrears of salary. Stop. Learned counsel for the petitioner, however, has submitted that the amount of gratuity has been wrongly calculated. This is your submission.
Yes, and another is arrear salary. Advocate arrears.
He also submits that arrears of salary as calculated by the contemners is also not correct. So stop. He has accordingly submitted that this court's order cannot be said to be fully complied with. So stop. After having perused the materials on record and submissions advanced on behalf of the parties, we are of the view that no case of willful / deliberate disobedience of this court's order is made out of this court's order dated 29/2022. So stop. If the petitioner has grievance against calculation of the amount of gratuity or arrears of salary, comma, he is at liberty to either approach the appropriate authority in this regard or question the correctness of the said decision before appropriate forum. So this contempt proceeding stands dropped accordingly.
I'm appearing for OP3, OP2. I'm appearing for OP2 matter on behalf of Mr. Mahapatra.
Give us.
Item 15.
My lord, your lordship judgment is not yet complied, my
Your
lord.
lordship.
30th January 2023.
My senior will be election in another court, let that matter be passed over.
Let us see the gravity of non-compliance. Where is the order?
Yes, your lordship can straightway turn to page 30 at para 14.
Yesterday, we have filed a compliance affidavit online. We are submitting the copy to some of copies.
Let us just. Where is the order? Annexure?
Page 30, annexal 1 at para 14. Page 30. Judgment dated 30th January 2023.
The income tax department is to refund you.
My lord?
Refund some amount.
Yes, my lord.
You are due to get
TDS
refund.
amount, which is wrongly deducted.
Have they not challenged this before the Supreme Court?
Whether you have complied with the order or not, paragraph 14.
The brief fact of the case will be.
Whether 14 has been complied with or not.
No, lordship, till now, because there is a technical error for which we cannot refund the amount to the party directly. There are some procedure, we have issued a notice to them to comply that. Till now, they have not complied to that notice. With that notice, they have to follow that procedure, and but with that procedure only, the refund will be flow. Otherwise, we cannot flow the refund accordingly. We have issued a notice and something.
This is my lord, you lordship have this is the second time of this contempt petition. Earlier on 28, 22nd August 2023, Your Lordship has disposed of with a direction to comply within 3 months. Thereafter, they have not complied.
So they want to be somewhere else.
So they have to give money.
They have decided.
Your Lordship judgment is very specific. If they're not complying, because they have stated that if they have not preferred the highest forum, then ultimately your Lordship's judgment is for attend finality.
Who was required to comply with?
That is a contemporary one, that is ITO, CIT and ITO.
All right, ask them to hear.
Your Lordship, in this case, the order which has been ordered, we have filed an IA for modification of order. That IA number is 4213 of 2023, which has not been taken in the board. With that order, we have specifically mentioned why we could not comply with the refund. Yesterday we have also filed and submitting the copy, contempt, and with this copy, and again, Your Lordship, we have issued a notice to him after the first contempt. We have issued a notice on 3rd October 2023, specifying the details that in this procedure we have to file. Till now, they have not complied to that, and this accordingly, the procedural, the department cannot flow the refund. The mistake has been done by the insurance company, and they are challenging the court has ordered to refund that amount. We agreed, and we are to flow the refund, but the procedure, unless and
Do you dispute that TDS amount has not been deposited in your account?
No, TDS amount has been deposited. Your Lordship, to claim TDS.
Then you have appropriated that amount.
Lordship, what happened?
Your department has appropriated.
Your Lordship, once a insurance company, while paying the compensation, if I'll narrate the fact of the case, it will be clarified the better thing. But in the meantime, I'll be submitting.
All right, no. You, the order was passed on
30th January 2023.
30th of January 2023. From the date of passing of the order till today,
Yes,
you tell us what did you do?
Yeah, that's it.
All right.
Yes.
And if we are not satisfied with that,
Yes.
the punishment is guaranteed.
Your Lordship.
Yes.
So let's say.
All right, we are giving you this much of liberty. What else?
The matter may be passed over.
It is an admitted fact that this court's order dated so and so has not been complied with till date. First off, let so-called replies be filed on behalf of issue notice to which contender?
Contender 1 and 2.
1 and 2. Top so and so accepts notice on their behalf. So stop. Let the contemners file a so-called reply as to why a contempt proceeding be not initiated against them and they be not punished for gross disobedience of this court's order dated so and so. Stop. The contemners shall be obliged to give to furnish in their so cause the steps taken, comma, date wise, comma, by them for compliance of the said order from the date of the order.
Lordship, one thing can be added. We have issued a notice to them.
You may say that you had issued notice to them.
We have already filed yesterday. We have
You file it again.
We
File it again. File it again. Let's list this matter on 4 weeks when who will be present? When the Commissioner of Income Tax and the respondents opposite parties number 2 and 3.
Your Lordship, one thing.
On the next date, just a minute, on the next date, the court will consider the requirement of personal appearance of the opposite parties number 2 and 3 for framing of charge if in case the court is not satisfied with the replies filed on their behalf.
Your Lordship, one.
I-
Income tax release.
1 and 2.
Commissioner of Income Tax release.
1 and 2, yes.
Secretary release.
1 and 2, already.
Secretary. One in office contains one in.
Contemnus 1 and 2. 2, 3, 1.
Item number 16.
This case, at the outset, I would like to, please, Your Lordship, that contempt is no way made out, my Lordship. If Your Lordship kindly look at the order passed by this court, my Lordship, which is sought to be implemented, my Lord. That's order dated 14/10/2019, my Lord. May I read out the order, my Lord? None appears for the petitioner. By way of this writ petition, the petitioner has prayed for a direction to the OP number 1 to 3 to take action against opposite party number 15 and to direct the opposite party number 15 to release the dues of the present petitioner with a stipulated period. Considering the amendments made in
Just a minute, just a minute. This is item number
16, minutes, 1/6.
No. You are referring to 1410.
Minutes ordered at 14/10/2019, minutes.
Yes, so
Yes.
there is specific direction.
Yes, minutes. Now, minutes, there is a direction to minutes. Here, prayer was minutes to 1 to 3 minutes. And who is one? One is minutes. One is the Secretary Department of Atomic Energy, Government of India. 2 is the minutes Secretary Department of Panchayat Raj, Government of Odisha. And 3 is the Director Panchayat Raj, minutes. And 15 is a private party, minutes. Writ application was filed to seek a mandamus against the opinion of 15 who is not releasing the amount of the present petitioner. That was the prayer in the writ application. And this honorable court were pleased to grant liberty to the petitioner file a representation. And the representation was never directed to file before the collector Sambalpur. And representation, they say that representation container is the collector Sambalpur.
Because my lord, that work was a.
Yes, sir. And collector Sambalpur.
Let him, he has right to argue, yes.
My lord, but that work is carried out through the collector Sambalpur, my lord. Because the present petition is an NGO, my lord. He has done some work, my lord. And the Department of Energy and all this, that head office is Delhi, my lord. So the present petition representation to the collector Sambalpur. And that's why the direction. And then after there is a contempt petition, order, my lord. There was 11 September 2023. Then also they have not complied. And my lordship is directed on 18 March 2024. Then after they have also not called my lord. Even they would have to call us and they have to sort out the issues, my lord. Then after they have also not called my lord, but they are. It is only to consider representation, my lord, nothing more than that.
Who is the appropriate authority?
My lord,
Superintendent of police?
No.
You could have done that?
No, my lord.
You could have filed a representation before commissioner?
No, but collector.
Chief minister?
No, collector. But
why? The appropriate authority is not mentioned. So the direction is to the appropriate authority. How do you define?
That work is carried out through the collector Sambalpur. And the present petition's office is at Sambalpur also. There.
And who are respondent number 15?
That is the collector Sambalpur.
So 15 is a private party situated in Bombay, minutes. 15 is
Delhi.
If your lordship, it's minutes at Nilsson ORG Mark Limited, Mumbai, represented through Director Sri Akshay Kumar Path.
And what was your relief? What was your relief in the petition?
Well, to release the dues, my lord, for direction.
Who was to release the dues?
That opposite party of 15, my lord. 15 has to release.
He is the appropriate authority.
But it's a private party. Because it's a work mallet, it is a contractual work mallet.
You took this order. You obtained this order.
We did not appear.
Huh?
Did not appear.
And did not appear.
No.
No one appears. We are not satisfied.
Well, direction may be given to at least.
No direction further. Sorry.
This,
No further direction.
this is the second contempt part.
The item number comes on 60. Where is the writ petition? High Court? The writ petition is not there on the file.
Not.
Can?
Not that. Not.
Do you have?
No. You have writ petition copy. You have the copy of the writ petition.
No, writ petition copy I don't have because a dispose of case I couldn't get a copy of the writ petition.
Do you have?
No, my lord, I have to contempt. Contempt.
The petitioner had a grievance against 15. Who is he?
That is a Nelson mallet. There's a Nelson, ORG Nelson.
Against is not a party in the present contempt.
No, he is not a party.
Against one Nelson.
Yes, capital MS, capital A C
Give the
Nelson.
name.
I'll give you a C.
That was in the first content. We have- Let me see. I have not seen the limitation. Do not use this.
Limitation.
See.
The petitioner had a grievance against so and so, which was impleaded as opposite party number 15 in the writ application.
Yes.
The when the writ application was taken up by this court on 14/10/2019, there was no representation on behalf of the petitioner. Full stop. This court, however, passed the following order. Oh, third paragraph of the order. Okay. It is apparent from the said order, it is clear from the said order that the petitioner wanted a direction from this court to opposite party number 15 of the writ petition to release the dues within a stipulated period. Pursuant to the order dated 14/10/2019, the petitioner filed a representation before the district magistrate. The topic is the petitioner's grievance that the district magistrate has not disposed of the representation and therefore has committed contempt of court by not complying the order dated 14/10/2019. Stop. Next, we find force in submission advanced on submission advanced by Mr. Samantrayal and AGA that no contempt is made out against the collector for non-compliance of an order dated 14/10/2019, as he cannot be said to be the appropriate authority to consider the petitioner's grievance relating to a release of dues by opposite party number 15. So stop. We do not find it to be a fit case for initiation of any proceeding, which initiation of a contempt proceeding, which stop the contempt. This application stands dismissed accordingly. Yes.
Item 17.
Yes. Under the Honorable Court's order dated 18th July 2023 has not complied till today.
What is there in the order?
In course of hearing, Lord and Counsel for the petitioner states like highlighting their grievance. The petitioner have made a representation to the opposite party number 3 by the Annex 8, and the same may be directed to consider within a stipulated time to within the Lord and Counsel for the state has no objection. As agreed by Lord and Counsel for the parties and
You are referring to 6.2.
my lord.
Which paragraph of the order?
Yes, page 13, my lord.
17. All right. Which page?
Page 13, your lordship.
Not considered as it. It's a some instruction.
No, I can appear for the lots 3 and 4 lots.
So just you should have disposed of the petition.
Yes, I will obtain instructions. There's been first time listed. They will also grant me some
4 weeks allowed for the 4 weeks time is allowed for the state contemners. For Mr. 4 weeks time is allowed to enable learned AGA to seek instructions.
May I know 2 weeks?
So seek instructions as regards compliance of this court's order dated 8/7/2023, passed in WPC number 21272 of 2023.
Item number 18.
Non-compliance of order dated 11/9/2023, passed in WA number 1929 of 23.
Lots may call it next week only, lots. I can obtain instruction lots.
As requested. Allowed 1 week.
Item 19.
May please. May please, your lordship.
Yes, your compliance has slowed down, Mr. Samantra.
Yeah.
Yes.
Your compliance, rate of compliance of the orders has slowed down.
No, lots now.
Hey.
Oh, so far as today, lots I have complied with almost 70% of the complaint lots listed today.
All right.
And most of the cases are first time listed. And I will see that next time lots all are complied with.
Yes.
May please, your lordship. Your lordship, the non-compliance of the order dated 19/12/2023 in WPC number 40854 of 2023. The relevant order portion is page 13, running page 13, 1-3. And your lordship kindly see the paragraph 3 and 4. So they have not complied the order dated 19/12/2023.
Man, disposing the face admission. So, my lord, copy solved, my lord. I am for the Commission of Fundament, my lord. My lord, the matter is disposing the face admission.
I will thought your lordship for a moment, your lordship, kindly may permit to read your lordship's paragraph 3
In course of hearing, the learned counsel for the petitioner prays for withdrawal of this petition, seeking liberty to approach the learned commissioner of endowments Odisha by filing an application for consideration of his prayer for grant of NOC for getting the compensation amount released in his favor. Thereafter, your lordship, next paragraph 4, granting the liberty as aforesaid, the writ petition stand disposed of. In the event such an application is filed, the London Commissioner of Endowments would be well to consider the same on its own merit and dispose of the same in accordance with law at earliest date. So I have
what is
approached.
the early date?
I have approached you lordship before the commissioner.
When? When did you approach?
Your lordship kindly turn to page your lordship, that is page 14, annex 2.
So what is the early date?
That your
You
lordship-
applied, the order was passed in December 2023. We are in April 2024. And you filed contempt petition in the meanwhile.
No, they have, your lordship, I have tracking my report also. I have annexed 3.
We will not see anything. We will see the order.
Yes, sir.
In the order, there is nothing. The
So
petitioner
let them consider my
has-
application only.
Let them consider the petitioner alleges disobedience of this court's order dated 9/12/2023, passed in WPC number so and so. So by the said order, the petitioner was granted liberty to file an application before the Commissioner of Endowment with a further observation that he shall consider the same on its own merit and dispose it off in accordance with law at an early date. Full stop. The said order does not give any timeline for disposal of the petitioner's application. In our considered opinion, no such disobedience of this court's order is made out so as to constitute contempt of this court. Stop this application, comma, for the present. Stop. It goes without saying that if there is any further delay in disposal of the petitioner's application in the light of this court's order dated 9/12/2023, if there is any inordinate delay, further, comma, he shall be at liberty to take appropriate steps in accordance with law.
May I pray one thing, your lordship, kindly specific in within a stipulated period.
We
your
cannot modify that order.
All right.
Item number 20.
But item number 20 and 21, it's only Kotak only, my lords. There was a direction to consider the, my lords, give the opportunity and consider the, I will obtain instruction only next week, your lords may call it, my lords. Collector Kotak.
As requested on behalf of the contemners, list these matters on 2 weeks.
21.
2021, my lords, connected same, my lords.
2021.
Item 22.
Lord, judgment was passed on 28/3/23, directing for payment of the minimum wages to the petitioner. And also we have represented them with the statutory copy of the order 19/4. But till now it has not been complied with. Of course, the direction was to opposite party number 6, with the Sarpanch. But why I have implemented 1, 2, 3, because it is the state government scheme and state government sanctions the money, and opposite party number 2 is the revenue and dispatching officer. Executing agency is only the Sarpanch. So, as your lordship, if lordship will say though directly there was no clear direction to opposite parties 1 and 2. That is true, because I have stated in my paragraph 5 why I have implemented them as parties. It is, if your lordship will say that only notice will be issued to opposite number 3, that is a different issue. But I have implemented opposite parties 1 and 2 only for that limited purpose, because sanction has to be made by the opposite party number 1 and opposite party number.
Let's see what is the order.
Order, my lord, lordship, kindly see page 26. Page 26.
Yes.
Para 16.
Yeah.
This court accordingly allowing the writ petition directs the opposite party number 6 to extending the minimum wages benefit under the notification since 25 to 2015 to 2021 to enter into calculation on the payment of arrear wages to the petitioner in terms of gazette notification issued by Labour and ESI Department since 24/7/2015 in the calculation paid up to the last notification dated 2/11/21 and find out the arrears required to be paid to the petitioner. Arrear as per calculation following the direction of this court be also released in favor of the petitioner herein at least within a period of 1 month, and payment of arrear be made to the petitioner within a further period of 15 days.
So this order has not been implemented.
It has not been implemented.
Why?
No, sir. If you also find that it's a specific direction to the Sarpanch of the Gram Panchayat.
That's what I was saying.
OP number 6.
OP number 6 is Sarpanch.
Now opposite party number 3. That's what I was making mention, my lord. I have implemented the opposite parties 1 and 2 only for effective.
All right.
That lordship may issue notice to OP3. So far as 1 and 2 are concerned, even though they are not the container, still then I can take instruction from the executive officer.
Ask your list this matter on. Issue notice to
OP3.
Opposite party number 3. List this matter on 8 weeks.
Yes.
Item 23.
Well, all the batch of cases similar. 22, all the cases. What's the play?
23.
May I please, Your Lordship? My lord, non-compliance of order dated 12/10/2023, my lord. Lordship, kindly have a glance at page 9, my lord. In the original lead petition, my lord, the petitioner was seeking for appointment on the rehabilitation assistance scheme under the 1990 rules.
Yes.
Plus, I will obtain instruction, even though there is no clear-cut direction within time stipulated, still then I can obtain instruction in this matter from the nurse office.
This Suchitra Bala case, have you gone to Supreme?
At that time, instruction also.
Suchitra Bala. Notice?
My lord, notice has been issued.
No stay.
No stay, my lord, in Suchitra Bala case. And the matter has been fixed to 29th of April.
Then lordship may call it after the holidays because it's only on Suchitra Bala's strength they are filing.
It is listed on 29th of April, my lord.
List this matter on 4 weeks. So 4 weeks as jointly requested on behalf of the parties.
Item 24.
That this proceeding for non-compliance of your lordship's order dated 2/11/2023. That the operative portion of the order at paragraph 3.
Page.
Paragraph 3 at page 10.
Private parties agreed to dispense with that land.
No,
To
This
the,
is a dispute
For
with regard
huh.
connection of a road to a public tank.
Public tank.
Two
Yes.
private parties have donated the land. But the Kisam was Jalasaya, it was converted to Sarada. Thereafter, the Tahsildar made a file a affidavit before this honorable court that there is no impediment for construction of the road. Accordingly, your lordship directed the commissioner to take, and the commissioner has also admitted that through his counsel. And your lordship stipulated 3 months' time. That was expired on
The commissioner is to reply.
expired on 1/2/2020.
The commissioner is to reply.
Yes, ma'am.
The
Commissioner
commissioner has to reply.
CM's.
Mr.
Notice has to go.
Mr. Devashish Naik appeared.
Yes, ma'am. Devashish Naik was appeared.
He appears
At the
for,
time of hearing of the writ
municipal
petition, he was
corporation.
appearing.
Or is it, yes, अच्छा, to this is fixed. We'll take up the matter tomorrow.
Yes.
Ask Mr.
Devashish like to be present in the
to be here.
Tomorrow perhaps is a holiday.
It's holiday day after tomorrow.
Day after.
18. Tomorrow means
Yes.
18.
Item 25, your lordships. Item 25. Limitation is shown for the period of 6 days. In fact, there is no limitation. Certified copy period has not been taken consideration by.
So we'll take it up tomorrow.
Tomorrow, day after tomorrow.
Day after.
Along with the IA, I have filed your lordships. Because the registry has shown that limitation is there, I am bound to file one application. Therefore, I have filed it IA number 2001
All
of
right.
2024. It may be taken up along with that.
26 is also same, my lord. Let it come on Friday, my lord. I have filed the IA that has not come. Friday.
Deployment.
Once you go for, if we start e-filing of the cases, then whenever you file an application, that will be automatically tagged. So this this
tagged.
complication will not be there.
Seeing the list, my lord, I have filed it. That is the.
So we are making attempts
For my-
to ensure that
Because
we go for.
I am assured, my lord, that there is no limitation. Because within limitation, I have filed.
Filed an application, he has, he wants some time. So I pray Lordship may take it up, grant me 4 weeks time so that it's a PIL, Lordship. 4 weeks after Lordship may call it so that I can file that report.
Who is for the petitioner?
Yeah.
Who is for the petitioner?
I'm for the petitioner.
My friend is for
Do you
it.
have any objection?
I have the copy, madam. No, I have no objection.
Your Lordship, 6 weeks after so that in the meantime, I will, without any fail, I can file that affidavit.
The, who is he? Who is he? What is? 6 weeks.
6 weeks.
So been filed. Then I would restrict it to say, what about the rest 133 or whatever? Those remain.
Yes.
Now, my lord, may kindly see the impugned order. It's begins from page 256. I'll only quickly run through the relevant paragraphs.
You are referring to?
The impugned judgment of the Honorable Single Judge. That is running page 256. Would be annexure 6. It begins from page 254. The text begins from page 256.
Direct computer based design.
May I please?
Computer based. Computer based, 299. 300. 400. Keyboard is a
Page number?
Page number 256 is a part of annexure 6.
Page 299.
256, got
256, next page. Yes.
Yes.
So this is the opening paragraph where the prayer has been quoted, and the policy dated 11/3/2020. Annexure 3 is contrary to so and so. That prayer portion has been quoted there. Then from the next page onwards, the prayers of the other writ petitions have been extracted. Page 257, 258. What would be important would be page 260, paragraph 2, wherein the Honorable Single Judge records what is the basic challenge. Paragraph 2, the opening lines are, on a careful reading of the reliefs quoted herein before, it is emerged that in all these writ petitions, the petitioners essentially seek to quash the notification dated so and so, issued by so and so, pursuant to the policy framed notification dated 14/5/2018 for rationalization and consolidation of schools under so and so department as well as so and so. Paragraph 3 would be important as to why the facts of the other cases were not discussed, because that was one of the grounds, my lord. Page 261, paragraph 3. In the course of hearing, Mr. S. Parida, learned senior standing counsel appearing for the state, contended that since notification dated so and so and subsequent office memorandum dated so and so have been issued pursuant to the policy decision of the government taken wide notification number so and so dated 14/5/2018, thereby to justify such policy decision, counter affidavit has been filed by the opposite party number 1 in so and so, and the same is adopted in all cases. So no individual counters were filed. Only in this case, the state chose to file one count. Then in paragraph 4, the consent is recorded regarding this. The facts of 27401 of 2020 shall be referred. And the main contention of the council appearing before the Honorable Single Judge is recorded in paragraph 6, which is at page 263. And towards the middle in page 264, it is recorded that the main ground is that the merger cannot be sustained as the same is violative of the provisions of the Right to Children to Free and Compulsory Education Act, read with Orissa Right to Children to Free and Compulsory Education rules. I'm placing this from page 264. And below that, they then take note of reflected, that contention is reflected at page 265. May I just place that? First para of that page 265. It is further contended that under the Act 2009, there is no provision for limiting roll strength of the students in a school. In the name of rationalization and consolidation of schools as a policy decision of the government, the roll strength of a school cannot and should not be limited to a particular strength. It is further contended that the policy decision of the government cannot be contrary to a statutory provision governing the field, particularly the Act 2009 and the Rules 2010. It is also further contended that it is the central government which is empowered under the Act to remove the discrepancies. Therefore, if any difficulties are faced by the state governments, they have to approach the central government under the provisions of law instead of framing a policy on their own for merger of schools, which is contrary to the provisions of law.
So this, according to this, there is no policy of the central government for merger.
In a way, yes. In a way, that's what the Honorable Single Judge.
No. Is this the correct position?
There, I must have to concede that, my lords, if they want to merge, say, two schools which are within that 1 kilometer radius.
So You want to merge is one thing, within 1 kilometer is another. But merger itself, whether it is impermissible or not, under the scheme of the central government or
What I would humbly submit, my lords, is if they are coming up with a policy of merger, then it has to be in sync with the central government rules and their own rules. You can't have a policy of merger which contravenes the central government rules, the act. What is more important
but
is also
what
an act.
It says the merger of schools is not permissible.
My lords.
So this observation possibly is not correct.
My lords. On a standalone basis, if one has to say that the rules, the act, and the state government rules do not allow merger, then that may not be the correct position, because of course merger is possible, but as I was trying to give an
Yes, you are
example,
right.
merger of two schools within 1 kilometer in accordance with the
In
rules.
accordance with it.
In accordance with the rules, there should not be any problem. But here, if I stopped at the policy, I'll show that each of the clauses of the policy which violate the act, the rules. And here, my lords, the policy is mounted on a principle of role strength. That neither the act visualizes nor the rules visualize. And that is precisely the finding of the Honorable Single Judge.
No, making a provision,
My lords.
say, new provision, which may not be there in the central act or the rules, and making a provision which is contrary to the rules. Say, what is there in the RTE Act, the state government can make provisions better than what is provided under the Act.
My lords.
So that cannot be challenged on the ground that it is not provided under the RTE.
And the key word here would be better. Here, what has happened is the central, I'll show that specific provision
You are right. When you say better, that was just by way of illustration.
My lords.
That because of absence of something in the provision, any action of the state government can be said to be contrary to that. You will have to demonstrate that this action is contrary to a specific provision of the act or the rules.
My lords, I would.
All right.
I have
That
got
is
that
the-
list before me.
If that contravenes, yes.
My lords.
If it is different from what is there, but does not contravene, then the matter would be different.
Let's to fill in a gap, these administrative instructions can come.
Guidelines, Annexure 1. Rationalization of schools issued by Ministry of Human Resources.
Reasons for, my lords.
96,
My lords.
page 96, just after the bold letters, while analyzing the status of existing schools,
My lords.
the working group
Noted that
there were several primary schools
within
a radius of 1 kilometer, less than 30 enrollments.
My lords.
So they have devised a notion for rationalization on the basis of enrollment, roll strength.
But the distance criteria, my lords, is there within a radius of 1 kilometer. So here, my lords, what is the major anomaly between the policy and the rules is this distance criteria. Now the central government rules under Rule 6, the state government under the very same Rule 6. I would also bring in the parliamentary debates. I have brought them, my lords, where they have said that this distance is something which is key to the implementation of the RTE Act. Now, this distance criteria is something which would stare at them for all times to come. If the rules say specifically 1 kilometer for 1 to 5 and 3 kilometers from 6 to 8.
No, but in that case, you will have to demonstrate
My lords.
that a particular person, forget village,
My lords.
a particular person cannot go to the school because that distance, the distance of the school is more than 1 kilometer.
It is not the state's case that in these 140 writ petitions which have been allowed, in all cases the distance is within 1 kilometer.
Is it your case? You have to prove. It is the duty of the petitioner to prove that he is being denied the benefits of right to education act.
In the lead matter, at least the single judge has come to a conclusion that it is beyond that 1 kilometer issue. It's about 2.8 is what the finding is, based on whatever maps and all. I don't want to go into that, but it is not the state's case, as my learned AG.
And even if we accept everything which you are submitting, the factual aspect, legal aspect is different, factual aspect. It is difficult for the High Court exercising power of judicial review to hold. It is again for the executive to ensure that it is implemented in accordance with the. All right, we will see.
Well, that's a point against me. I take that. Policy decisions, how far they can strike down, those judgments are against me. But here, what would be the point in my favor would be that you are having a policy which squarely is contravening your own rules and the central government rules.
Yes,
and
please.
The words used are shall within that 1 kilometer. And I'll show the central government guidelines also, which I have brought. That this one, even in, I'm grateful to my Lord Justice Raman, my Lord, there it allows consolidation, but within that 1 kilometer radius. Nowhere that 1 kilometer, because then my lords, at least what I understand would be, then you are going away from one of the core values of this act, because the reasoning is that a child cannot walk beyond to.
Yes, if we stick to that 1 kilometer formula mathematically, then sub-rule 4 will have no application. Sub-rule 4 will have to be excluded.
I bow down to that, my lords. Now, sub-rule 4 says that you can have exceptions, but the grounds for the exceptions are not roll strength. The exceptions are geographical barriers or flood-affected areas. The exceptions are carved out there. Even the word of similar nature is in there. So the exceptions are carved out in sub-rule 4. None of them say that roll strength is a ground for merger of this kind. And that is precisely what the Honorable Single Judge holds. So if you want to take resort to those exceptions, then your policy should have been mounted on those exceptions. Like, my lords, I have seen from the central government website, hilly states of Northeast, they have all gone to the central government to
hilly
seek.
States of your state, Odisha, some of the tribal area.
Well, this policy is not mounted on those exceptions. Had it been that, yes, these are the reasons, and then we are coming.
We are not entering into that. We are not saying, because this observation is what? Nothing. I mentioned tribal area. Tribal area, do I know which place? And even if I know, can I record that in my order? So just based on perception that there must be tribal areas, there may not be schools, and so that cannot be.
Yes, my lords, I do concede, my lord, this is quite a complex issue which cannot be dealt with in a very casual manner. But my lord may also, my humble submission would be that my lord may have to test this from the extreme angle of dropouts, of people who don't have access.
Absolutely right.
My lord. So my lord may visualize why this 1 kilometer is being harped upon. Even the debates, one of the members, he said that you have to stick to this 1 kilometer, because that is what would make education accessible. So that analogy, and my lords, the rule doesn't rule. It says that you shall have to have the school. The word shall is used. So as I proceed, my lords, I'll show that schedule also in the act, which has also been tried to be contrary.
All right, please proceed in your own manner.
Page 265.
Yes.
The Honorable Single Judge records. It is further contended that the policy decision of the government cannot be contrary to the statutory provisions. It is further contended that it's the central government which is empowered under the Act to remove the discrepancies. Therefore, in any so and so, this I just read out. Now, this is another important violation which the Honorable Single Judge records, page 266. It is further contended that wide notification, transport facilities for children of so-and-so have been provided while issuing the notification for implementing policy decision of the government for merger of schools, which is not permissible under the rules 2010. It is emphatically submitted. This line, my lord may see. Further, that rule 6.2 of the rules 2010, when provides for upgradation of schools, merger of schools is not permissible and any action taken also cannot sustain in the IO.
So
Now-
this is the core.
Now, if my lord would just pause here and kindly see 6.2 of the state rules. I had placed 6.1a, which is the strongest point in favor of this judgment. Six one A, according to me, would be our strongest point, which says that in respect of children in classes 1 to 5, a school shall be established within a walking distance of 1 kilometer of the neighborhood. And in respect of children of classes 6 to 8, a school shall be established within a walking distance of 3 kilometers of the neighborhood. Now, 2 which has been ignored would be, wherever required, the government shall upgrade existing schools with classes 1 to 5 to include classes 6 to 8. In respect of schools which start from class 6 onwards, the government shall endeavor to add classes 1 to 5 if necessary. So, what the Honorable Single Judge records is that this 6.2 has been.
Now, if we start reading the provisions literally, then this would mean that after framing of rules in 2010, the school shall be established. So all these schools, new schools will have to be established after 2010.
That's what.
Irrespective of the fact that there may be schools already existing. Are we clear?
No.
So if we read those rules in that way, then those schools which were existing prior to 2010 are not to be taken into account for the purpose of these rules.
No, but this has to be read in conjunction with 6.1. So basic criteria of 1 kilometer is important. So suppose there's a school within that 1 kilometer, this would not mean that you have to establish a new school, say 300 meters away from the
It
existing.
says shall be. In future, it will have to be established. I'm not saying that this should be the interpretation. We're just saying that the provisions are to be something purposive construction as
In
a
fact,
whole.
what falls from your lordship was a part of the parliamentary debates and also the clarifications given by the standing committee, where they said that this word neighborhood appearing in clause 6.1, this is too vague. And there has been a clarification issued by the government regarding interpretation of this word neighborhood. And I bow down to what your lordship says regarding the exceptions. Now, 6.4 does provide exceptions, but that exception is vis-a-vis places where hilly areas. In fact, I'm grateful to your lordship. The amendment which was brought to my notice, my lords, it says that for children from small hamlets, children in urban areas as identified by the government, local authority, where no school exists within the area or limits of the neighborhood specified in sub-rule 1, the government shall locally make arrangements such as free transportation, escort, so and so, in relaxation of the limits. And the exceptions would be in clause 3 of rule 6. Now, what would be important would be that on the basis of roll strength, you cannot merge schools and carve out these exceptions. You have to follow 6.3 which basically says that in places with difficult terrain, risk of landslides, flood, lack of roads, and in general, danger for young children in approach from their homes to the school, the state government local authorities shall locate the schools by reducing the limits specified in sub-rule 1.
So this rule 3 is an exception. And rule 4 has nothing to do with rule 3. Rule 3 is one exception, rule 4 is another exception.
My lords. But what I was trying to submit, my lords, and what the Honorable Single Judge records is that the exception on which this policy is mounted is role strength. And if my lord would straight away see the schedule under the central enactment, there's a schedule which can
Now, let us, when we interpret statutory provisions, we can have hypothetical situations also. And it says for children 2 kilometers from that place, there is a school. So there should be a school, according to you, within 1 kilometer for the 4 children. And you should have the teachers and the building and everything for this hamlet.
In a way,
the situation can be visualized, and the situation which we are explaining is not impossible. It's possible also. So therefore, there is one thing which we call viability. Viability is also to be seen. Having school, suppose one says that yes, within 1 kilometer we have one school, a building we have constructed, that building is there. The child can go. Then you can say the teachers are not there. All right, we will see. Teachers are also there.
But that is something, viability, now the policy.
The whole idea behind this, the merger is viability. It seems.
So viability, it's also to improve the standards of whatever the existing schools have. It's also to bring in more teachers. It would be more practical. All that is well taken. Now, but my lord has to see that from the point of view of, now, had the policy been mounted on this, that in small hamlets, we cannot provide. Now, my lord has to see the policy on the objectives of the policy. What the policy aims at is where there are less students, you merge them. So the basic bedrock of that policy is role strength. Now, what the Honorable Single Judge has proceeded with is, you cannot have that as a basis because the rules don't provide that as a principle. And what would be crucial here, because at least, my lords, the Act rules, of course, would be of the same force. Now, my lord may see the Act itself. There's a schedule which only the central government can change. If you have problems, you have to go to the central government because this is central government funded. The schedule would be just after the Act, after section 39 of the Right to Children to Free Education Act, the schedule under sections 19 and 25. Now, the Honorable Single Judge has analyzed this portion of that schedule. My lord may see the number of teachers for 1st class to 5th class. And admitted children is up to 60. So what the Honorable Single Judge holds is that if the Act provides no minimum criteria, no minimum intake, you cannot tinker with this schedule of the Act in view of the provision under section 20 of the Act, which says the power to amend the schedule is with the central government.
How do you say that this provision has been tinkered?
Because this provision says up to 60. Now, when they are saying that if children are up to 60, then how can you have a criteria that if my schools would have children, say, below 15 in KBK areas here, and below 20, then I'll close down that school. Because here, if there are children, say, let me take the figure of 10.
They are not closing down that school.
No, the policy aims at that. The policy aims at closing down schools where children are below 10, below 20, and in KBK areas, it's below 50. So that is the specific violation vis-a-vis the schedule of the Act. And that is precisely what the Honorable Single Judge holds, that when the central government enactment has, now the key word here would be up to 60.
Yes.
So the Act doesn't say a minimum. Had the Act provided this, then maybe you could have done. Now the specific objective of this is to close down these schools where the children are below. Suppose there are 19 children, it can be closed.
Suppose there are 5 children. Why 19?
Well, I'm trying to, suppose
when we start supposing,
we have to take it to the extremities. Suppose there are 3 children, then also, of course, but then, my lord may kindly my lord has to see this in the context of the reach, because why this enactment came was to make it more accessible to the lowest common denominator. In fact, one of the MPs says that why this one kilometer is very important.
Yes.
In any case, I'm trying to submit, my lords, what the Honorable Single Judge has recorded, that here the word is up to 60. So how can you have a figure of 20 or 15 when the central government says that it's up to 60? That means it's a I get your lordship's point. Suppose that means for one person also you have to open a school. That if that argument comes, then it becomes unviable. I get that point, my lords. But then this has to be balanced out. Then probably this policy has had to be run through the central government, as some other states have gone there. They have sought for exceptions, and the government has relaxed. This has to be read in conjunction with Section 20, which says that the central government alone has the power to modify. And all this has been analyzed. Even if this is a provision under the concurrent list, this has all been analyzed by the Honorable Supreme Court. Section 20, your lordship must have seen, the central government may by notification amend the schedule. The key word here would be by notification. Amend the schedule or omitting therefrom any norms and standards.
That is, there cannot be any dispute over that.
The Honorable Single Judge also records Rule 6.2, which says that if you have existing schools, you have to upgrade. And hence, the Honorable Single Judge records that instead of upgrading, you have here basically decided to close down. There's a violation of 6.2. Then I have already submitted about 3 and 4. The policy is not mounted on these principles. It's on role strength. Role strength seems to be the guiding principle, which neither the Act nor the rules allow. Now, if my lord would just have a look at that policy, where I just showed the table of the Act. The policy is a part of the convenience note, page 9. Yesterday I had placed out the main provision which was violated. The policy begins from page 6 of the convenience note at flag 12.
Yeah.
I must straight away say that merger of schools, which has fallen from Honorable Justice Raman, merger of schools within that 1 kilometer radius is permissible. There should not be any problem. That would be in fact more viable if there are no students, but the key would be that 1 kilometer. Now here in that policy, it repeatedly mentions that irrespective of distance. Now, I must show, my lords, this government, the clause 1A, government elementary secondary having enrollment of less than or equal to 20. Now, this has been modified subsequently to include 15 for KBK areas. And that amendment is at page 215 of the writ appeal, wherein they have reduced. For KBK areas, it would be 15, and for others, it would be 20. So the moment you have a school which is below 20 in general areas, then that may be liable to be merged. And the policy which contravenes the rule would be this line, irrespective of distance. And then to further elaborate on this, the policy at clause F shows of that rule 3A 1F, government primary upper schools with low enrollment are liable for consolidation in terms of table 1. So this low enrollment is also something which neither the central government rules nor the act they specify. Then there is one more violation of that schedule of the central government enactment, is consolidation of one or more primary schools with a 5-class secondary school. Now, the two ranges which the act provides is 1 to 5 and then 6 to 8. Here they have a separate range of theirs. So if I can submit this, my lords, this would encroach upon the schedule, because schedule specifies a particular ratio number of teachers. By having 2 categories, here they have their own category. And then section 20 would come into the picture. You are modifying the schedule of the act without taking the permission of the central government. That this is at page 8 of that convenience note.
Page 8.
Page 8 of that convenience note. Types of consolidation.
Page 8 is not there.
Of that convenience note at page. It's also there at page 160 of the appeal memo. I hope my lord got it.
Yes, got it.
Consolidation of one or more primary schools with a 5-class, that is 6 to 10, and 7-class, 6 to 10 secondary school. So this is tinkering with that central government schedule. I'm choosing the word carefully, my lords. It's tinkering. Then, my lords, page 9 of that convenience note, the table. This table is again what the glaring contravention here would be. Again, distance and enrollment are critical criteria to be considered in consolidation. Now, serial number 1 of this entry in that table is a glaring contradiction, because it says 20 or less and whatever is the distance. Then again, they have got these numbers on their own. Less than 40, we will close down for the primary school. That's entry number 3. Here also, there is a modification. This 20 or less has been reduced to 15 or less. And that would be at page 215 of the writ appeal, where these numbers have been changed for KBK areas. Another violation of that schedule of the central government enactment would be at page 10. In case of vertical integration of physical consolidation of schools with greater than 40 students, the availability of classrooms available in the school to which so and so. So even with greater than 40, they would change it. Now, this is also tinkering with the central government schedule. It's a part of the act itself. Now, another aspect which the Honorable Single Judge has recorded would be at para 13, page 278 of the writ petition, of the writ appeal. At page 278, the Honorable Single Judge gives the numbers of all the writ petitions which were heard. Page 278, paragraph 13. In paragraph 14 at page 284, the Honorable Single Judge takes note of the note sheet from page 284 onwards, and the note sheets have been extracted from page 284 to page 302. And the conclusion vis-a-vis these note sheets is at paragraph 42, which appears at page 336, wherein the Honorable Single Judge records that while coming up with this policy, you have not specifically taken note of Rule 6 and the enactment and the schedule there. So, if I can submit, my lords, the decision-making process has also been questioned here. That finding would be at page 336 of the writ appeal, wherein specifically the note sheets have been mentioned, and then it said that you have not taken note of Rule 6 of the state government rules and the Act.
So note sheet of the department.
Of the para 14, the note sheets have been extracted. Records were called for, and the note sheets have been extracted fully. So the extraction is from, it's about 16, 17 pages. The entire para 14 is devoted to that.
Do we do that? All right.
I'm just saying, this is what the Honorable Single Judge has done. He has extracted the note sheets, and then he has come to a conclusion that while taking a call on these policy matters, you have not referred to Rule 6. This is the conclusion. My lord may see the conclusion at page 336. Last paragraph of page 336. On perusal of the relevant note sheets referred to above, it reveals that while taking a decision, the authorities have not taken note of the provisions contained in the Act of 2009 and the Rules 2010 as discussed above. Therefore, this court has jurisdiction to interfere with the decision-making process as has been held by the apex court in a category of decisions. If in the decision-making process there is non-compliance of the statutory provisions, then the ultimate decision suffers from illegality and irregularity with which the court can interfere. Now, an important paragraph would be paragraph 16 at page 303. Para 16, the facts narrated above are not in dispute as it appears the government in school and mass education for so-and-so and office so-and-so in the shape of guidelines and consolidation of school, the principles as enumerated in clause 3(1)(a) of the notification laid down that within open inverted comma, government elementary school having enrollment less than or equal to 20 to be consolidated with nearby schools irrespective of distance was modified by issuing a corrigendum dated 14/12/2020 at page 1. So this is at page 2155 of the writ appeal. And the modification has been taken note of.
Mainly 2-3 points are there. One, merger is impermissible. According to you, merger is permissible if it is within 1 kilometer. And what else? While taking the policy decision, Rule 6 has not been taken note of, and what else?
If I can list that out, my lords. First would be that the schedule of the act has been completely ignored. Schedule says up to 60, this should be the benchmark. Here you are coming up with a figure of 20 and upwards, 15 in case of KBK. So this benchmark of 20 is in clear violation of the schedule under the Central Act. Now, for modifying the Central Act, you have to resort to section 20 of the Act, and that power is only with the central government.
No, see, had it been 70 in place of 60, that would have amounted to tinkering with the with that schedule. But if it is 50, if it is 40, then how can you say that this amounts to tinkering with?
No, it has to be read in conjunction with the other provisions. Suppose it says up to 60.
Let us see the schedule again.
My lords.
Now, this is for the purpose of this lays down the norms and standard for a school.
My lords.
And for that reason, this is for the first class to fifth class, admitted children up to 60, number of teachers 2. So the policy which the state government has taken, you could have said that this amounts to tinkering with this provision in 2 circumstances. Had this 60 been raised to 70, or this number of teachers been in place of 2, 1. So if they say that number of teachers will be 3, then can you say that this amounts to tinkering with the schedule?
This, in conjunction with my earlier submissions, this word up to says that means that there is no minimum limit. I bow down to what your lordship says. If it is 2, you cannot possibly run a school with 2 children.
No, we are not saying that. What we are saying that this admitted children up to 60, state government may take a policy decision that admitted children up to 40, the number of teachers shall be 2. All right. In this case, you cannot say that the state in its policy has tinkered with this schedule. But if in place of admitted up to 60, it says 65 or 70, then of course, yes. Similarly, in case of number of teachers 2, the government takes a policy decision 1, then again. But if the government takes a decision that it will be 4, because this is the maximum limit and this is the minimum limit. It's maximum limit of students and minimum limit of teachers.
Now, why I'm harping on this up to is fixation of this minimum strength of 20.
This is different for a different purpose altogether. This is for the purpose of which you are referring to, item number 1. This is for the purpose of fixation of number of teachers. Only,
my lord. Now, what the Honorable Single Judge has recorded is that since it says that there is no minimum student intake in this schedule, you cannot come up with a policy.
Then this is unreasonable. That finding cannot be upheld.
Now they have come up with
they say up to 60.
My lord.
Up to 60 means what? Up to 60 means from 10 to 60.
My lord. Up to 60 would mean from 0 to 60.
We said 10. 0 cannot be there.
1 to 60.
1 to 60. For 0 student, there cannot be 2 teachers.
So now this is what has been interpreted. I'm just showing.
I don't think. Up to 60.
Now what has happened is, irrespective of distance, schools will be closed down if the student intake is less than 20. Now, what the impugned judgment says is that since the central government enactment and the rules don't have this minimum student intake.
See, the maximum which can be done, this is my tentative view. The maximum which can be done is that some responsible officer, some responsible person may be asked to inquire, to see as to whether there is any such situation where the students are not able to go or are required to go beyond 1 kilometer for a school. This is a factual aspect.
What would be here, because we also have a similar situation in Rajasthan where they have struck down the policy on this distance criteria alone, which the
We shall also strike down the criteria. If that is the requirement, and that is very quite valid requirement, if it comes to us, we will surely. But there has to be, see.
a similar situation arose in Rajasthan. The single judge has followed that judge.
On factual finding, on the finding of fact that a particular school is beyond 1 kilometer of the neighborhood, the policy cannot be struck down. The policy will have to be tested with the act and the rule.
As I just read out from the policy, my lords, the distance criteria is
Distance, absolutely right. The moment we see, the moment we find that that criteria as a matter of policy has been overlooked, then surely we shall hold that. Or we can lay down that law. We can lay down a guideline.
In fact, the state government in writ appeal, in one of the grounds, they have said that you should have struck down the policy only to that limited extent of distance. Other things should have been kept intact. They wanted that reading down. It's one of the grounds I just read. That could have been one of the approaches, my lords, where they could have asked the government that, all right, you make your policy in sync with Rule 6, so far as this distance is concerned. But let me show, my lords, what the standing committee says regarding distance, because this policy would have an impact also on food security. Because
we are giving you another example. If the distance of a school is 1.1 kilometer from a neighborhood, all right, then what will you say?
Those are difficult.
No, we are just discussing. What will you say?
Well, I do bow down. Well,
No, just answer. We have something different in our mind. Therefore,
I would say, Malaj, that there is a violation.
Exactly. And we agree that if there is a circumstance where a child has to go beyond 1 kilometer, then there is a violation. It has, the 1 kilometer is the maximum limit. Beyond 1 kilometer, only with the aid of 4, school can be, the policy or the action of the government can.
4 and 3.
So the moment 1 kilometer is the maximum that we appreciate.
In fact, I bow down to your lordships. The policy has been struck down only on, that's the major point, that it says irrespective of distances, we will go by roll strength. And we will close down schools if the number is below 20.
That they cannot do.
That is, and one of the grounds in the writ appeal is that if you found that that clause of ours is wrong, you should have read it down. Very fairly.
This ground has been taken just to tell the division bench that
as a backup, latching on to that
what are the limitations of judicial review?
My lords. No, that could have been one of the solutions before the single.
Solutions was. Right.
In fact, the learned AG is very fair. In many cases, my lords, he agrees in case there is some error. He goes back to his drawing board and then comes back again with a rectified thing. But this, of course, couldn't have.
This time he is not doing that.
No, no. Before the single judge, he wasn't there before the single judge. Otherwise, maybe the results would have been different. I'm not saying that, my lords. Here, in fact, he's very fair. So, there's a specific finding regarding roll strength in paragraph 16, that you can't have a policy decision on the basis of roll strength regarding merger of schools. Para 16, at page 307.
That is also at the core of the issue.
Roll strength, and your rules nowhere specify roll strength. Then para 17, the Honorable Single Judge records about the provisions of the Right to Education Act.
Now, suppose there are two schools within 1 kilometer of a neighborhood. In one of these schools, the number of students is say 10, and in the other 30. Then what should be done?
It can be merged. It can be merged. The moment the 1 kilometer criteria is met,
Why?
Grateful to
On what
Honorable Justice
basis?
Raman,
No, it can be merged, you are right. It can be merged, you are right. But why?
Because the right to access to education here would not be faltered.
Because of the strength, because of the number of students, which you are saying should not be a consideration. Number of students,
Pupil-teacher ratio. Pupil-teacher
pupil-teacher ratio. So for this reason, the merger is permissible also on the ground of the strength of the students. That can be.
My lords. In fact, while recording this judgment, the Honorable Single Judge has gone by the policy. The policy doesn't have room for these kind of mergers, what is now falling from the court. The policy embarks on a journey which simply says that on the basis of roll strength, irrespective of distance, we will close down schools. That is something which has been faulted with by the Honorable Single.
That cannot be done.
And that is basically the essence of the judgment. Repeatedly, the Honorable Single Judge records that.
See, we are of the prima facie view that primarily because in the first case, the distance according to the state was 0.1 kilometer, and according to the Google map, it was 2.9 kilometer. That, it seems, with the
now individual facts, my lords, as I said, that could have been
that cannot be gone.
My lords, but then the manner in which it was conducted, it's not the state's case that in all these 140 writ petitions, it is within that. Had it been the case, then things would have been different.
So therefore, we are saying this, that we can issue direction. We can require a responsible officer to ensure that this provision is not violated.
In fact, what I can share, my lords, off the record, my lords, the learned AG, whenever these things come for the state, he would have probably, that's what I can take his words, my lords, he would have told the judge that, my lords, let me go back, I'll have a better policy, which is in sync with the rules, and then we can work this out. Because obviously you can't have, it's very impracticable to have a school with 2 to 3 students and then it being closed down. So the merger has to take place to improve quality. My lords, basically it's about a balance.
See, we agree totally,
my lords,
that 1 kilometer criteria cannot be violated. All right. 2, there is exception to that criteria that is there under sub-rule 4.
3 also.
3 or 4. 3 or 4. It is there in the policy rules also. So that is the only circumstance in which this 1 kilometer can be deviated from. There is no doubt about it.
I was also, I must be candid, my lords, I was not appearing before the Honorable Single. Now, this kind of a scenario would emerge if the state comes up before the court and volunteers that, all right, we are willing to relook at our policy, then we go back and come up with a better.
You have a measure to approach.
No, that grievance, now the grievance redressal, my lord, with great respect.
Grievance redressal, that we do not agree.
No,
the view which has been taken that.
But then the grievance redressal mechanism.
The grievance redressal forum is not a judge of his own cause. and they are not judging, they are not adjudicating
My lords,
any.
I would not join issues there. My lords, the grievance redressal issue can be closed in this manner, that if you sustain this policy, then the grievance redressal body would be bound by the policy of the government. They cannot go beyond the policy. And the moment the policy says that this 1 kilometer distance is not to be
There
taken,
you are right.
my lords.
There you are right, that if this is the policy,
My lords.
then grievance redressal forum cannot go beyond the
Policy
terms of the policy. But if something is pointed out to the grievance redressal forum, cannot be said to be an eyewash. It's a mechanism.
My lords, I'm
people
not
can
submitting
commit.
regarding the grievance redressal. I'm not. In fact, that paragraph is also not there in my list to be shown to your lordships. What would be important would be some of the provisions under section, which I'm reading from the judgment itself, para 23, page 316. The definition, it says that what a child belonging to a disadvantaged group, because this would be in the context, I'll be going to the debates very quickly. This would be in the context of that. Child belonging to disadvantaged group means a child with disability or a child belonging to scheduled caste or scheduled tribe, the socially and educational backward class, or such other group having disadvantage owing to social, cultural, economical, geographical, linguistic, gender, or such other factors. Now, this word geographical also may be important in the context of that 1 kilometer. Then, my lords, section 6 of the Act, duty of the appropriate government and local authority to establish school. For carrying out the provisions of this Act, the appropriate government and the local authority shall.
There is no accessible road. Lead track. Lead.
I'm just reading out from page 317. Section 6 has been taken note where there's a direction that the government or the locality shall establish within such area or limits of neighborhood. Now, this expression within such area or limits of neighborhood as may be prescribed a school. Now, this prescription has come about by invoking 38 under the central government rules and the state government rules. So here there's a policy which contravenes this. Then power to amend the schedule, section 20, I just read out. The schedule under section 38, page 319. The schedule has been extracted at page 319. Now, the mistake regarding this amendment to the Orissa rules, that is also there in the impugned judgment. I must point that out. Page 321, clause 4, the pre-amended version is there.
Yes, 2010 was taken. 2011 amendment has not been taken.
My lord, the light was there. All of us were laboring on that old rule, including before your lordships.
Yes.
Only your lordship told us it has been amended. And I am the victim because it was a state rule. I should have got it amended in the first place.
But in any case, that amendment is not something which would, had there been a major amendment in 3-1, in the 1 kilometer thing, then probably we would have been out of court. This is something which, of course, is very important, but this is not something which is germane in the judgment. This clause 4 is important. Of course, transportation and other things, the state has come up with transportation allowance for, I think, the scheduled areas. I'm just trying to show, my lords, what the judgment records. This is what the judgment says. Then, my lords, what would be important would be page 320 and 321, where the rules have been noted, and then paragraphs 25, where the actual reasoning has come about. Now, at this juncture, my lord may kindly see section 38. of the central enactment. Uh, 38 gives the rule-making power. The appropriate government by notification make rules for carrying out the provisions of this act. In particular, without prejudice to the generality of the foregoing provisions, such rules may provide for all or any of the following matters, namely special training. B would be very important. The area or limits for establishment of a neighborhood school under section 6. So the rule-making power specifies that you have to have an area or limits for establishment of a neighborhood school. Now, invoking these powers, the central government has come up with rules. Then there are the state government rules. Both the rules have been violated by this policy. Then the model rules are also there. The model rules have nothing regarding distance. Model rules were shown by the learned AG. They have nothing regarding distance. So pursuant to this 38, there are 3 documents. The rules of the center and the state have been violated in this policy dish. That is the finding, my lords, of the Honorable Single Judge in para 25, taking note of all these provisions. Now, the analysis which probably the court doesn't agree regarding that 60, that up to 60, that analysis is there at page 324 in the impugned judgment. Page 324, just above paragraph 26. Section 38 of the Act provides the power of the appropriate government to make rules. Under section 6, the schedule appended to the Act, so far as primary schools are concerned, that is for classes 1 to 5, for admitted up to 60. 2 teachers are required for classes, at least 1 teacher for social studies and languages. Similarly, Rule 6 provides establishment of neighborhood school, walking distance of 1 km. Then 3 km for 6 to 8. Then the conclusion comes at page 325. Therefore, combined reading of the Act rules nowhere there is any provision for merger, consolidation of primary/upper primary schools with high schools. Therefore, the notification number so-and-so dated 11/3/2020 regarding consolidation of various types of schools, including high schools with classes 6 to 10, 6 to 10, 1 to 10, 9 to 10, with primary and upper primary school is contrary to the provisions of the Act as the very definition of the elementary education wants. So basically, the Honorable Single Judge records that you have to have this class mentioned 1 to 5 and 6 to 8. You cannot have these. This I had shown earlier. Then para 27, roll strength issue has been discussed, where the Honorable Single Judge records that when there is no minimum roll strength which has been prescribed for a primary school under the Act and the rules, the notification can't be contrary to this. So that finding is in para 27. Then in paragraph 29, the Honorable Single Judge records, I'm reading from page 328, Your Lordship's brief. Besides that, when the very purport of the Act and rules is to provide at least 1 school within a walking distance of 1 kilometer of the neighborhood, in that case, the state government cannot and could not take steps for abolition of schools which are already there and catering to the needs of the local. Therefore, in the guise of merger, consolidation of schools, the very purpose of the Act and the rules have been frustrated. This finding comes about in para 29. And then in para 42, of course, the finding regarding the factual finding is there in paragraph 32.
That we have seen, Mr.
Mallots. And para 42, I just read out earlier, is regarding the note sheets. I'll not take much time, my lords. In the convenience note, I have mostly covered in a very short span. I have covered this.
Yes.
There are 2-3 additional documents which we will just show. These are 3 documents. One is a guideline issued by the central government. That's from page 1 onwards. I'm just placing page 1 of that compilation. Guidelines under section 35 of the right to so and so regarding education in a neighborhood school. Now this neighborhood has been italicized. I'm placing from page 1 the subject, dated 25th July 2011. Now the relevant portion would be at page 4 of that compilation. I'm sorry, my lord, it's quite faded. I have downloaded it from the website. In providing for right of every child to free and compulsory education, a neighborhood school, the Right to Education Act does not restrict the choice of the child to seek admission in a school which may not be in the immediate vicinity or the neighborhood of the child's residence. In other words, there is no compulsion on the child to seek admission only in the school in his or her neighborhood. Then chapter 4, these are clarifications of the central government. Duties of the appropriate government, local authorities and parents. Section 6, for carrying out the provisions of this act, the appropriate government and the local authority shall establish within such area or limits of neighborhood as many as may be prescribed a school where it is not established within a period of 3 years from the commencement of this act. Now, next line, my lords, is very important. The rationale of this provision is to provide all children access to elementary education. Universal access requires schooling facilities within reasonable reach of all children. If schools are not located in or near the habitations where children reside, children may not complete schooling, even if they are formally enrolled in schools on account of distance factors. The Right to Education Act therefore mandates the appropriate governments and local authorities to provide for children's access to elementary schools within the defined area or limits of neighborhood. Therefore, a neighborhood school is a school located within the defined limits or area of neighborhood as notified by the state government under the state RT rules. Now here the state RT rules have this specific limitation of 1 kilometer and 3 kilometers. 1 kilometer for 1 to 5 and 6 to 8 is 3 kilometers. The central RT rules have notified the area or limits to a factor in distance norms, 1 kilometer for children. So that's also recorded.
So there cannot be any dispute over that. 1 kilometer criteria will have to be there.
So then the moment you have a school which ignores this, I'm sorry, Malaj, the moment you have a policy which ignores all of this, then the only option.
Then the policy can be read down to that extent. The policy can be read along with the rules and the act.
If I can submit here, my lords, I may be wrong.
All right.
Subject to what the AG says. Now, there's always this controversy of reading down. On the moment the government says that yes, there's something
this is
wrong.
not read down.
No, I'm just submitting, my lords, in this process of reading down. If the government says that yes, there is something wrong, you kindly protect my other portions, but read down the ones. But unless the government volunteers, then the courts normally, if they see that there's a...
Unless we see that some policy is contrary to the rule, then only. So far, the factual aspect of whatever the finding has been recorded on the facts, we'll be dealing with how to, whether any guideline is to be issued, direction is to be issued, that can.
So the policy, so far as this distance, I need not repeat that. Here it says that what fell from the court with provision for relaxation of norms in places with difficult terrain where there be risk of landslide so and so. So this entire policy in the objectives, my lord, would not find this. That's what the Honorable Single Judge also records. That they have nowhere said that we are doing this for these reasons, landslides, floods, lack of roads. These are not or danger to children. None of these have been in the objectives of the policy. Policy goes, my lords, with great respect to that.
Does the policy say that it will breach the requirement of 1 kilometer from the neighborhood? Is there any provision in the policy?
Yes.
Where?
My lord, may kindly see that straight away that the policy itself is mounted on my lord, it's there in the clause page 6 of that convenience note. Page 6 of the convenience note, which is at flag 12. The objective, my lord, first objective is to reduce the number of educationally and economically suboptimal schools. Now, straight away, the violation would be clause 3A1, which says government elementary and secondary schools having enrollment less than or equal to 20 to be considered where nearby schools irrespective of distance. Now, this in conjunction with the table, the first entry. Now, any primary or secondary school where the number of students is 20 or less, irrespective of distance, will be closed down or will be abolished or merged. Whatever word I use, the effect would be the same. So this, my lords, in black and white is a clear violation of this, of the central government rules and the state government, their own rules. And this is what precisely the Honorable Single Judge has reflected repeatedly in the impugned judgment. Now, it also says at page 5 of this new compilation, states, union territories need to arrive at a clear picture of current availability of schools within defined area or limits of neighborhood. So the state government, the central government in 2011 has come up with these guidelines that you have to have your availability and then implement. So this distance criteria has all along been there. Now, this is a policy which completely ignores the distance criteria. And that's the reason why it has been struck. Now, if my lord would see, so just to persuade your lordship, page 17 of that compilation, which is a report of the, it begins the report of the Rajya Sabha Standing Committee. And the relevant portion would be at page 17 of that compilation, which says, committee's attention was drawn to the term neighborhood school as provided in clause 3.1 of the proposed bill. The committee notes that this term has not been defined to enable the state governments to determine and prescribe the criteria for a neighborhood school on varied factors like geographical, cultural, and social specificity of the state. The committee, however, would like the inclusion of distance/time for commutation as one of the criteria for neighborhood schools so that young children do not have to commute long distances which may cause exertion. This criterion can be different for plains, mountainous regions, deserts, etc. The committee therefore recommends that the term...
that is the only provision in the policy which says that irrespective of distance. That is the only thing in the policy.
That is the only thing which glaringly contravenes. That's the reason why I have been repeating that. That is something which glaringly contravenes.
They'll take care.
Other small ancillary contradictions are there regarding this strength.
All right, we'll take care of that. 1 kilometer.
1 kilometer also, if my lord wants, there was a member who also spoke about this. where he said that he himself is a member, it's parliamentary debate, just to persuade your lordships. Page 27 of that compilation. One line which, if I can read out, it's a Tamil version. He said that you may construct thousands of chol trees, you may establish 10,000 of temples, but nothing is so sacrosanct than providing education to the needy poor. And then he goes on to say about his own story at page 29, last paragraph. As regards neighborhood school, I congratulate the government. The so-and-so is known for its practical approach. From 1st to 5th standard, I studied within my village, and 5 to 8th standard, I had to walk 7 kilometers. And in all, it was 14 kilometers. And ultimately, my lords, he requests the government that you have to have this 1 kilometer now. It should be within 1 kilometer only. It should not be beyond 1 kilometer. You have to take care of it. Now, my lords, the Honorable Single Judge has taken note of a series of judgments. I have just culled out 4 judgments. Now, my lord was already aware of that. My lord. First judgment would be regarding that maintainability. It's a part of my convenience note. That relevant portion also I have quoted it.
No, but maintainability part is over.
Maintainability, there's a judgment of the Supreme Court which says that you have to have individual
SLP. Niranjan Biswal.
Niranjan Biswal. I'm grateful to you.
He says that appeals have been filed in all the cases.
No.
All the 7 cases.
All 7, but what about the other 130 odd cases?
Take care of.
130, because the interveners before your lordships are all beneficiaries of those judgments. Some of them, they have come before your lordships taking this ground specifically from day one.
Interveners had come for what?
To be heard. Well, that would not rectify because all of them haven't come. Some of them have come.
Interveners had right to oppose the prayer,
my lords,
not to support.
No, interveners are opposing the state.
Not a state in the writ petition. In the writ petition, where the interveners were there or not?
These interveners were writ petitioners. They succeeded before the Honorable Single Judge.
So
here they have intervened.
All of them are interveners?
No.
All of them are not.
Some of them. And there this judgment would come in which says, after we have heard the learned counsel for the parties, Niranjan Biswal had given this order earlier.
So you are referring to Lakshman Dundappa and Ranjhod Singh and Mahadev Bhau.
My lord, regarding that policy, how policy went, this is the first judgment would be this regarding maintainability. It's an unreported order. SLP order.
21 cases were disposed
21 cases were disposed of, my lord.
So against single writ appeal was filed.
So here around 140, those numbers I just showed, my lords, from the judgment.
Yes.
So this single writ appeal may not be maintainable. This we are specifically taking, my lords. Then
No,
so
there
far
are 7 appeals have been.
Yes. One has come. So far as I think they have filed it later. I'm not sure when they have filed it. But in
Now,
any
this common judgment
my lords,
confines to 7.
my lords.
So all the 7, as per learned ages submission,
They have probably filed it with delay.
maybe there.
My lords.
Technicality is removed.
My lords, next issue would be that what about the other judgments which are beneficiaries of this? The state is aware of those judgments. The interveners have annexed those orders, and they are specifically saying that if you entertain this and strike down.
See, we assure you that no party shall be prejudiced by any judgment which we shall deliver.
Regarding the some judgments regarding that to what extent they can go and quash policy. First one would be Mahadev Bhau Khilare, para 7. I'm just placing that. Indisputably, the state of Maharashtra has framed recruitment rules. Any scheme by way of an executive instruction in terms of Article 162 of the Constitution of India, if violative of such statutory rules, would not be legally sustainable.
Sorry.
Similar view in Punjab Water Supply, that is 2007 2 SCC 491.
They are all referred to here. Punjab Water Supply.
Punjab
Ranjore,
Water Supply has been referred.
and
An important addition would be this judgment in 2001 8 SCC 378. Now, paragraph 9, my lord, may kindly see.
Lakshman case.
This, my lord, is Lakshman Dundappa Dhamnekar. Paragraph 9. We have noticed earlier that the appointment and conditions of service of teachers in a private government-aided institution are governed by provisions of the Act and statutory rules. The said provisions are a self-contained code relating to appointments of teachers in private aided institutions. The field relating to method of appointment of regular teachers in a government-aided institution is fully covered by the provisions of the Act and the rules. And we do not find any provisions in the Act empowering the government to supplement the rules by executive instructions. It is no doubt true that if the Act had empowered the state government to issue administrative instructions by way of supplementing the rules, the position would be different. In such a case, the government would have the power to fill up the gaps in the rules by issuing administrative instructions if the rules are silent on the subject, provided the same is not inconsistent with the statutory rules already framed. In the present case, the Act does not empower the state government to supplement the rules by issuing administrative instructions or orders. In the absence of such provision in the Act, it is not open to the government to supplement the rules by executive orders. So this paragraph, my lords, would cover the entire scenario in this case.
Here this Act provides a rule-making power of the state.
My lords. Here it's our point is straight away, my lords. The rule-making power is provided under 38. Under that, under Rule 6 of the central government rules, the rules have come in. There's a specific 1 kilometer and 3 kilometer criteria there. Under Rule 6 of the state government rules, there's a 1 kilometer, 6 and 3 kilometer criteria there. The policy, without referring to those rules in any manner, has done away with that 1 kilometer criteria. And there is also some, subject to your lordships accepting it, some amount of tinkering of that schedule is what I'm trying to contend under the Act. And 20 says that you have to go back to the central government if you want to go beyond. This, I'm deeply grateful, my lords. Thank you. Regarding my friend, my lords, in person, he has appeared, his case.
Please come.
There's an intervention which is at flag 11. He wants his school to be demerged. He wants that, he's an individual. He wants his school to be demerged. Merger has happened. He wants it to go back to that.
And may I make a statement? May I make a statement? Since he's come individually, I will have a look at his application. We have demerged 43 schools. If this qualifies for demerger, your lordship may take it from me, lord, I will have it.
Please come.
In fact, my...
1 minute, आप इधर सुनिए.
There's a table there. I think my learned AG.
Learned AG କହିଲେ ଆପଣଙ୍କ ସ୍କୁଲ କନସିଡର କରାଯିବ ଷ୍ଟେଟ ଲେଭେଲରେ ଯଦି ସେଟା କ୍ୱାଲିଫାଇ କରୁଛି ଡିମର୍ଜର ସ୍କିମ୍ ସହିତ ତାହେଲେ ଆଉ ଥରେ ଡିମର୍ଜର ପାଇଁ ସେମାନେ କନସିଡର କରିବେ ବୁଝିପାରୁଛନ୍ତି ଆପଣଙ୍କର କେସଟା ହଉଛି ଅଲରେଡି ମର୍ଜ ହେଇଯାଇଛି ବର୍ତ୍ତମାନ ଡିମର୍ଜ କରିବା ପାଇଁ ଆପଣ ପ୍ରେୟାର କରୁଛନ୍ତି ସେଇଟାକୁ ସେ ଷ୍ଟେଟ ଲେଭେଲରେ କନସିଡର କରିବେ ବୋଲି लर्नेड एजी कोर्ट को अप्रेज कले आज
ठीक है
सेतिक हेले हबो आपनकर जदि स्कूलटा से क्राइटेरिया भितर आसुची ताहले पुणी आउथरे रिकन्सिडर करिवे से माने हैना
We provide a copy to the learned AG.
Sit here, after this hearing is over, I'll speak to you.
We are all grateful.
he is a teacher
He's an individual. He's
Individual.
filed an intervention
But
here.
what I understand is, he says there is a highway running.
Oh.
So that may be a valid criteria.
maybe,
I will
yeah.
have a look at it.
At
Lordship,
flag-
rest assured, Lord, if it's a case for demerger, I will enter.
His intervention is at flag 11 and the table he's relying on is on the last page of that intervention. I'm grateful my friends would supplement. I'm really grateful.
Thank you. No.
Plus, my friend has already covered all the points which I wanted to place before.
You missed the chance.
Yes, my lords. No, my lords. I subscribe to his submissions, Your Lordship, that what he has submitted, that I was also intending to make that. But some points, so far the merger of schools are concerned, Lordship, kindly see the cause list. Many lawyers are there, they are also representing the intervenors. And so far the other appeals are pending. I have counted those numbers, 147 writ applications pending. Lords, one judgment I will cite, Lord, that is only recent judgment. Only 6 appeals have been filed and belated. After, Your Lordship kindly recollect, on the date when I made a mention that stay order is operating against us, therefore, Lordship kindly take off. And also, by I made a mention that the although 147 writ petitions were filed, but they have come up against one, my lord. And the Lordship indicated that you don't give hints that they will prefer the appeal. In the meanwhile, they might have filed. Lordship kindly see paragraph 5 of that judgment with regard to the filing of one against all the lords out of a common judgment. Lords, paragraph 5. I'm sorry, I have no copy, extra copy to supply to Lord AG. Data copy, yes. In impugned order, the court held that separate appeals ought to have been filed by the appellant against the decree given by separate appeals have not been filed against both the decrees. Res judicata would operate as against the findings given in other suit even after consultation. Thus held that the cause of appellant foreclosed by applicability of principle of res judicata. In the present case, only except this, the bearing 7, other writ applicants, they have not preferred an appeal. Lords, therefore, even if Lordship decides...
No, Mr. Counsel, this order was passed in 7 writ petitions.
Yes, Lord. No, Lords. 7 writ applications where, Lords, the counsels were present before the court, they made some mentions because their Lordships have Lords mentioned this fact in the judgment also.
Mr. Counsel,
my lord,
this order which is under challenge was passed in 7 writ appeals. 7 writ petitions. Is it incorrect?
No, my lord, sir, that is correct, but 7 writ applications represented by the respective counsel, they made some...
We are again putting the same question.
My lords.
The order which is under challenge was passed on 7 writ petitions. Whether this statement is correct or not.
Lords, I will stand to Lords, little modification I want to bring to
Just a minute,
notice.
come to the order.
Lords.
Come to the order of this court.
Lords. Your Lordship is correct to the fact that...
Correct, then please don't make unnecessary submissions.
Lords.
7 writ petitions, the order was passed. Therefore, the estate cannot challenge any order passed in some other proceeding.
Lords, in the present case, Lords, 147 writ applications are filed.
Filing and disposal, these are two different
These are
things.
mentioned, Lords, writ application, Lords.
It's very difficult for us to convince you. This order was passed in 7 cases. This order might have been followed in 100 cases. That's different.
And this judgment deals also at paragraph.
The prayers made in those cases only.
So discussed this judgment proceeded on the basis of prayers made in 7 writ applications, right?
Yes, Lord. So one case was taken up as a lead case, therefore.
Mr. Counsel, whether 8th case was disposed of by this order or not.
Yes, Lord.
8th.
Lord, the out of Lord 7, Lord, lead case was the first case, that Amarmunda case is the leading case.
Yes. All right. Any other point? With that
Lord,
point, we have understood.
Lord, my humble submission of your Lordship would be, Lord, the Lordship kindly see the policy says where the consolidation is not possible. Consolidation of schools not, Lordship kindly see page 333 of the appeal memo. Page 333. Page, sorry, 233. Page 233.
Yes.
This is Lord's office memorandum dated 11/3/2020. And the heading is cases where consolidation is not possible. Clause 8. In case a school identified for consolidation needs to continue functioning, the district-wise list of such cases has to be placed by the DEO/DPC before the DLSCC headed by the collector. This signed exemption list is to be sent to SPD OSEPA by 20th March 2020, and only after approval of the government will these schools be allowed to continue. The key reason could be as follows. Enrollment in the school has increased and is above the threshold, less than 40 for primary schools, more than 20 for UP secondary in the consolidation policy. B. Distance of lead school from the satellite school is not, as per the threshold, 1 kilometer for schools between 21 and 40 enrollment. C. Natural barriers limited to rivers without bridges, mountains, forests, national highways, without subways, overbridge where cassette and safety is a challenge. Well, these are the grounds on which the consolidation is not possible. Your Lordship kindly might be aware of the state Lord's condition. Our state is a pro-cyclone and flood state. And most of the area is a poor and poverty-stricken area. Lord's, the one Lord's mention has been made by the Honorable Single Judge that actual fact and records are different. If your Lordship may be out of record, your Lordship kindly excuse me to bring to your Lordship's notice what I have heard when the policy decision, the public
Please don't make these submissions.
Well, your Lordship, since the entire gamut of exercise is the public interest of the students, the paramount consideration of the students, how the student would reach out the school.
Mr. Counsel, please come to the point.
My Lord.
Legal, if you have any legal submission to make.
Yes, Lord, this is my
If
legal.
you have any legal submission to make beyond what has already been made, please do it. Otherwise, we will take into account each and every aspect.
Lord, this is my ground. I have also in my writ application taken the stand. Geographic barrier is my one of the most vital stand I had taken. That has not been answered. And your lordship kindly see.
That has not been answered by whom?
Lords, not answered by the appellant in their rejoinder. I particularly.
In their rejoinder, had you raised this point in your writ petition?
Yes, my lords, I have raised this point, geographical barrier.
So whether that point was answered by the learned single judge?
My lords, they have stated in the manner the forest.
Mr. Counsel, you had raised a point.
My lord.
Which has not been considered by the learned single judge according to you.
My lords, considered. For that the judgment has given in my favor, but judgment is like.
No, whether this geographical aspect has been considered or not.
Yes, judgment aspect has dealt with.
Geographical aspect.
Yes.
Has been considered.
Yes, my lords. My humble submission, so what I beg to persuade the lordship is, this is the one of the ground for which the merger is not possible, and the policy decision itself says these are the grounds, these are the criteria for which merger is not possible. My lords, the lordship kindly see another aspect. The learned single judge has been brought to your lordship's notice. A man cannot be judged for his own cause. Your lordship kindly see the next page, 2, 3, 4. Here, my lords, the collector has become the DLSCC head. And grievance redressal committee, my lords, what I heard from learned AG that whatever grievance anybody has to put up before the grievance redressal committee. After the merger is approved, this is a situation after the post-merger situation. The persons whose school is merged.
We will see that those judgments have been referred to in the judgment.
Yes, my lords, they have been taken note of.
We will examine.
My lords. My lords, another aspect what I beg to submit to lordship is, the schools which have been established in the state.
Yes.
My lords, I would refer to, my lords, that is Orissa Aided Education, Establishment, Recognition, and Management of Private Upper Primary Schools Rules 1991.
Yeah.
Lords, there, lords, the
yes.
Schools are to be established after passing through different stages, lords. Making application, then permission, then recognition. After completion of all these formalities, school will be established and will allowed to run. Lordship, kindly see Rule 20, which specifically say that minimum roll strength prescribed. That I am reading with Lordship's permission. The minimum effective strength for each standard of a private upper primary school shall be 30.
Who are you? You are father of any student?
Millards?
You are father of any student? Your client is father of any student?
No, secretary of the school, Millards. So
secretaries of the school, they have problem. Secretaries and teachers, they have generated all these litigations. So the children have no problem. Their guardians don't have any problem. But these teachers, these secretaries, these managing committees, they have problems.
No, Millards, because
they should settle with the exemplary cost.
They are
whether any guardian has approached this court or not.
Millards, any
guardian.
I have no knowledge.
Whether any guardian has approached this court or not.
I have no knowledge.
No knowledge, then unnecessary. You are challenging policy decision because you want to stay in a particular school, in a village.
No, that is not.
No villager has a grievance.
No, that is not the purpose. Purpose is that has to be passed through a prescribed procedure.
At least you should be removed in accordance with law.
My lords?
You should be removed in accordance with law. On demerger, what interest do you have?
Lord, school.
In the interest of these
minor,
students.
minor, small people, students, they will face a large number of difficulties.
Then where are they? Where are the guardians? Vested court's time? Challenging policy because we want to stay in a village?
No, lords, they have
or run the school.
They have established the schools. They are running the school.
Now we have understood the reason why the policy decision was challenged. Whether any public representative has filed, any sarpanch, any gram panch, any mukhya?
I have no.
I have not. Then only those persons who are running these schools. All of you will get observations. Yes, any other submission?
No, Lord, this is my submission because all the other parts my learned friend has covered already.
All right.
My lord, I have an appeal, my lord, that is WNO 690/2021. I have not challenged the judgment of Moab passed by the Honorable Chief Judge. My merger is not in accordance with the guidelines. Therefore, my
Now let us decide the main issue first.
main issue, this matter may take up later on.
They no, these 7 appeals, this appeal
it is
will
not within.
no. This appeal we will decide first. Other appeals shall be decided later. And if any other matter relating to this policy is pending, those matters shall be taken up
My
later.
lord, detach this appeal number 690/2021.
690?
One matter is
It is, I have not challenged the merger of that. I have challenged that my school shall not be merged with another school. Their school will merge with my school, my lord.
That we will decide your matter.
Decide later.
No, in this matter.
In this matter, my lord, let me.
Yes.
No, I have not. Lordship, kindly see the notification I have annexed.
Item number?
Yes, this is the appeal number item, it has been included. Read appeal number 690/2021.
690. Yes. What is your ground?
My ground is that your lordship can come to page 11 of my appeal.
11 of your?
My appeal. Memorandum of appeal.
Yes. So what about that finding of the learned single?
No, I have not challenged the merger.
Just a minute.
I have not challenged the finding of the Honorable Single Judge at all. I have challenged that in my case, the Honorable Single Judge has passed an order.
Who are you?
I am the secretary of his school, my lord.
Yes.
I have challenged the merger of my school. I am not against the merger, my lord.
You are not challenging the order of the learned single judge.
Yes, I have challenged, my lord.
You have challenged the order of
In
the
my
single-
case, which has been passed in my case, not its common case, my lord.
How can you challenge the order passed in other case?
No, my lord, what happened, my lord? I filed a writ petition.
Yes.
I said that my school is a lead school and the other
So
school.
your writ petition has no order has been passed on your writ petition.
Yes, that order has been passed, my lord. I have challenged that order, my lord.
So that is separate.
Separate, my lord. Separate order. That is Annexure 3.
This can be detailed.
All right.
Oh,
Here delay has not been condoned yet.
no, delay has not been condoned. Delay will be condoned, my lord. After it will be
Delay
hard.
has not yet been.
Let's list the matter under appropriate heading.
Delist.
Yes.
Short rejoinder, if you wish.
Please.
Yes. Lord, kindly see 256. Except the, Lordship will not look at anything. Except the first petition. All other writ petitions do not challenge the policy. What they say is that the merger or demerger is not in accordance with the policy. So therefore, per se, my lords, only the first writ petition says that the policy is bad, which your lordships are looking at. So I will not bother your lordships on that.
Now kindly see minutes. Rule 6, your lordships have seen time and again. Rule 6 never says it is the distance from school to school. It says distance from the neighborhood. There is no finding of the learned single judge that any of these mergers have violated the distance norm, namely the distance between the merged school is 1 kilometer away from the neighborhood. So this is the answer to 6.1. And your lordships have seen minutes that 6.1 and 6.4 have to be read conjointly in a given case. And 6.4 minutes, as your lordship showed us yesterday, says that for children from small hamlets, children in urban areas, as identified with the government authority, where no school exists within the area of limits of the neighborhood specified in sub-rule 1, the government authority shall make arrangements such as free transportation, escort facilities, residential facilities for providing elementary education in a school in relaxation of the area. So transportation, residence, etc., etc. My lord, even before 2020 came, your lordships had seen there was one 2019. And 2019, my lords, there is a notification at page 219. I will get it in my note, which in fact said prior to 2020 that we will give you transportation from the house to the school. So that was already there. Now, my lord, the next point I wanted to show, if your lordship don't mind, my lords, page 158. Your lordship will not open anything. Page 158, my lords, kindly see. This policy at page 159 also reiterates 6.4, while it says at H, during consolidation RT distance norms for access to upper primary schools may be followed. Alternatively, transport and escort allowance as per RT norms to be provided. Your lordship may just write down, I will give it in my note. It further gives one-time facility. Lordship will leave it. I will give it in my note.
All right, all right.
One-time facilitation allowance is to be provided for children who move from satellite school to lead school. So that is also there. In case of, because one argument was made and I told your lordship, this person who has come, the policy also notes, in case of geographical natural barriers limited to rivers without bridges, mountains, forests, national highways, the one this gentleman had, without subways or bridge where access to safety is a challenge, government may decide to relax the norm from case to case basis. So therefore, they won't be merged if these eventualities are there. Then, my lords, may 161, the table, it refers to distance from school to school. It does not refer to distance from neighborhood to school, because the rule says 1 kilometer from the neighborhood or 6.4 or this other one. And then, my lord, your lordships have seen that Rajasthan judgment which was referred to. I will give the citation. All that it says is the policy is right. We are not interfering with the policy, but there the distance between the school and the neighborhood was at a distance of 8 kilometers. So they said, since the distance between the neighborhood and the school is 8 kilometers, 6.1 is violated, we uphold the policy, but on a case-to-case basis, this has to. Your lordship may give me little time, we will file a detailed writ of such. Grateful.
And
Deeply
transportation facility you are providing.
Yes, yes. It is there in the policy itself.
No, you are
Providing or not is a different matter.
No, providing. I will file an affidavit. Your lordship is right. The policy will not depend on whether you are providing or not, but I will also file an affidavit as to what is being provided. My lord, since it fell from your lordship, don't mind. Kindly see what is the transport facility. Kindly, my lord, 219. I will not trouble your lordships with opening the page. Let me read what 219 says. And this is before 2020 came. In exercise of powers conferred under 6 of the right of children so and so, escort facilities for children residing in remote habitations with sparse population in habitation so and so, where the children face difficulties to access primary and upper primary school within the vicinity due to merger of satellite schools, low enrollment with lead schools and they travel beyond 1 kilometer to attend to the primary schools beyond 3 kilometers from where the children of the habitation have less population, so and so, so and so. My lord, what we give them is this. Where children face natural barrier, then what they are given is no cash will be paid to the beneficiary. I'm coming there. / beneficiary transport allowance, escort allowance. It will be paid through account pay check, bank transfer only to the beneficiary by calculating working days. The transport / escort allowance will be rupees 600. I'm sorry. The transport escort cost shall not exceed 6,000 rupees per annum. The transport escort allowance of rupees 600 per month will be paid to the beneficiary if the attendance of the child is 75%. Transport escort allowance will be 400 per month, will be paid to the beneficiary if an account of attendance is less than 50 to 75. And these are all paid by check. The transport facilities are 300 per month if it is less than 30%. My lord, all this is paid by check and all this is accounted. So I will deal with page 219 in my note also. My lord, deeply obliged, minutes. We have troubled your lordship for
25th February 2019.
Even before 2020 came, because the lordship saw 2018 there was another policy.
Thank you.
Grateful.
This is only in Goa. I just submitted. Bombay has taken it up suo motu. That matter is pending. Rajasthan was shown its stay. Guwahati, even though it's against me, my lord, Guwahati, they said that we will not embark on this journey. I'm giving those judgments in case your lordship.
My lord, your lordships wanted me to give a list of schools merged. Give me 2-3 days time.
Guwahati, the
a week's time is what, my friends.
1 week. 1 week.
1 week. I'm grateful.
Guwahati, the developments were approved by the Supreme Court. So this since I must assist your lordships regarding those judgments. There's a SLP order also. There they say that we will not go into this policy. But this 1 kilometer issue was not there in Guwahati. I'm giving those judgments.
In some of the cases matter that the girls system also merged with the boys system. So that's why he might not.
That should be done. That should be done.
That is the reduction of the road strength. Even road strength is high.
That is different. That is case to case basis. Let us decide the law first. Let us decide the law first. We will see. But you cannot take this plea that girls' school cannot be merged. They must stay together.
This stage of advancement of.
Yes, sir. Which is your matter?
37, sir.
37.
Item
Let us
37.
try.
I know, my lord, time is a constraint. It may not be.
Still, but we can begin.
Yes. On the last occasion, if you're not, this is regarding that 260 acres of land which was required for the industry. On the last occasion, the government served the copy of the counter. I filed a small rejoinder. If your lordships can just see that, I've given a timeline in that. Because how this 260 acres came and whether I have accepted, because they said that the communication says that I have accepted that 120 acres is enough. So I'll just prove to that extent, because apart from that, I have already explained before your lordships what was the issue. If your lordships would just have a glance at the rejoinder affidavit that I have filed, it starts, my lord, from page 161 of your lordships brief.
One 161.
161, my lord. That's what I think pagination, what has been done.
No, sir, I don't remember. Double 126.
No, my lord, 11268 of 2012.
222.
Annexer K by 2.
No, my lord. I'm sorry. Then maybe there is some mistake in the pagination. Maybe
2012 order.
My
You are
lord?
referring to 1/5/2012 order.
No, my lord. My rejoinder affidavit that I have filed, my lords. If it's before your lordships. That was filed on 12th, my lord, 12th of April.
12th of April. Then it
This-
would not have come.
That is on
12th of April. 2024.
That is in the physical file. I think it's there, may not be there in the scanned copy.
Yes. Friday.
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 Subject to your lordship's convenience, otherwise it can be.
Next week, my lord.
We are ready to develop the system.
No, my lord.
Immediately to tag up the original.
No, but the physical this thing is coming on record.
No, that is also not come. That has also not come.
My lord, they served a copy yesterday only.
Mr. Patnaik and senior counsel is saying that.
Served on 12th itself, the receipt is there. Maybe the senior may not have been briefed by that time, so maybe the briefing might have been yesterday. So if subject to convenience.
Tomorrow, my
lord,
tomorrow at 2.
may I pray if your lordships can fix it to 24th.
24th.
Subject to your lordships so that
24th already.
24th at 2 p.m. your lordships may keep it to.
All right.
And the interim order to continue till such.
Obliged.
Requested on behalf of the parties, place this matter on 24th to be taken up at 2 p.m. The registry shall ensure in the meanwhile that what have you filed?
Rejoinder. The rejoinder counter filed by the state government.
Rejoinder filed on behalf
OP
of
number
the petitioner is placed on record.
Item 38.
Okay. Lord, the interim order to.
Interim order shall continue in the meanwhile.
Obliged.
I may plead your lordship.
Which item? This is also at 2 p.m. Yes.
Yes, ma'am. I'm giving a dead shot to his lordship for convenience, no lordship. Understand the case in short time. Crux of the matter is that here is a case where promotion are two ways. One is second class, another is first class, meaning thereby those who are degree engineers are and not first class competent examination, they have been made two classes. They will get promotion to higher post, so far the degree engineers, and subsequently in their like CCR and advanced marks will consider. Insofar as those candidates, those who have possessed the qualification of first class master on competency examination of the engineering competency examination, they will be immediately after passing, they should be placed higher in the case. Let's take a look at the date sheet, madam. (9/9/94) promotion to the post of under manager in. There are two cadre also. One is under manager, one is manager. Promotion to the post of under manager E2 grade. 98. Promotion to the post of senior under manager E3 grade. 7/8/2007, madam. Passing of first class magistrate certificate of competency examination and represented for consideration of his promotion to higher post. Then it's 2007 also representation.
No, these are dates. What is the main point involved?
Main point also candidate come to the impugned order. There is 13, madam. My point was not at all taken into consideration. Let's say, can you look at on second page 14. The point I had raised that I should be availed an opportunity under first class after passing the first class certificate for higher promotion. That was never taken into consideration and I was ignored till 2017.
So what is the why?
Let's say, can you look at page 14 of the order of the. Or let me read out from page 13 also. L.K. Mahanti Learning Council for the petitioner submit that there was an anomaly on the promotion in MSCHS first class channel. The managers were brought over to the first class channel. One B.K. Behera has been given promotion to senior manager mining first class in EC grade by the order dated 20th 9, 2013. The petitioner filed representation to bring him from second class channel to first class channel as he has possessed master degree, first class certificate since 2007. But till date, the same has not been taken into consideration, though the juniors to him in service have been promoted to E grade in first class channel, indicating he has filed a representation, but the same was not been considered by the authority. Therefore, petition was approached by Lordship before the Lordship, which was disposed of on 14/2000, pursuant to which the chairman come Manzi Coalfield Limited considered the representation dated such as filed by the petitioner who was working as manager mining second MCL for promotion from E5 to E6 grade in first class channel at par with executive promoted by CIL order dated 20th 9, 2013. On perusal of record, opposite partner work called for the records for promotion and categorically stated the petition was promoted from non-executive cadre to the executive cadre to the post of under manager E2 94, subsequently promoted E3 98, further E3 to E4 2008 as per recommendation DPG held on such and such. So my point very consideration was that first class certificate has to be taken into consideration, was not at all discussed nor denied. On the contrary, peruse the record, there is no materials on record, we are not inclined to interfere. This is the next paragraph of the impugned judgment. So my entire contention, Lordship will look at the first paragraph, even by writ appeal, very limited prayer. That once the one Behera, who was promoted, who was not even completed the course, first class course, he could be able to get promotion higher than me, better than me. My case was not at all considered insofar first class certificate is concerned. That's my limited submission for Lordship, which was not taken into consideration by the Honorable Single Judge and was not dealt with. Because my entire contention was the first class certificate, which I had possessed in 2007, should be taken into consideration in terms of the policy decision, reckoning the seniority and promotion avenues. This is my limited submission for Lordship.
This is which service?
This is mining service, my lord, under the MCL, my lord. Engineering service.
Are there rules?
They have executive instruction issued from time to time. Even Calcutta High Court, I was getting a judgment covered by the decision, which has struck down the 2006 policy. But it is not legible, therefore I'm not able to give a Lordship. Let me type it out or otherwise somehow.
No, but what is there in the rule? Unless we have the rules or the executive instructions or whatever policy decision dealing with the rules, then how can we decide?
But I will check up because only they rely on executive instruction of 2006. My instruction is that has been already struck down by the Calcutta High Court. There is an order with me, but they are not legible, therefore I'm not able to. It's not prudent for me to give supply a copy to a Lordship. And another part is that they only rely on 2006.
Only?
Rely on a 2006 executive instruction, which may be available in writ petition.
So where is the provision that passing of first class manager certificate?
Yes, ma'am.
Is required for promotion to higher grade?
Let's say look at the impugned, that copy exactly is not with the 2006 guideline. If you'll also direct me, I can produce the same with a Lordship.
That was not there in the
writ petition, perhaps, because only engaged writ ballot.
It's not.
Maybe writ application may be there. And they have not filed a counter even in that.
Counter was not filed.
This is
the court did not file any merit.
No. The point raised that first class was whether first class will be taken into consideration or not. That has not been dealt with. That is my contention before Lordship, my lord. My entire contention is that, my lord.
Mr. Counsel, your contention should be supported by some material.
But
It
admittedly,
is not that whatever.
forget about that, but I'm admittedly junior than one Behra. That I've categorically stated in abhorrence throughout. Senior. Forget about my lord, fast. So far the point you are lordship raising, because I'm not able to answer to lordship at this stage. My humble submission is forget about that. But I am admittedly senior than many others. But they have given promotion 2011 and 13, where I was given promotion in first class in 2017. That your lordship also get from page 13, annexure, page 33, annexure 13. Let us look at my lord, the language used. In terms of OM number such and such, 2003 following manners mining second.
No, you are reading what?
Page 33, my lord, annexure 13.
Whether annexure 13 was there in the writ petition?
Yes, ma'am. Writ appeal, I'm on appeal. I'm on appeal.
Sir, whether this document was there in the writ proceeding?
This application, that document must be.
It was not there, it seems. Section 13. Writ appeal. And our mind does not work. Our minds do not work in the absence of statutory provisions.
There is no statutory provision so far my instruction
All
is
right,
concerned.
any rule, any executive instruction, any basis, any policy.
This is executive instruction. Let it come tomorrow, madam. Let me be more educated and come to your lordship on the issue. Tomorrow, day after, let's say.
Appellant is this matter on Thursday.
So I can prepare a note and meet your point, your lordship. Day after tomorrow, proceed.
It was there as Annex 7, page 20. That document.
I'll check up with them, come back to your lordship.
Item number 27.
Yes, these are the batch of item 27 batch of cases, my lord.
Bharat Parida.
Hold on.
You have to go back to single.
In fact, my lord, Honorable Chief Justice has also passed the same order, but I don't have. Yes, my lord, same, the issue has been revisited and another order, so it has to go back. All the matters.
Item 28.
Your my lord, I am for the respondent, the appellant is not here, probably. The thought
What
it
is
will not
this?
teach.
What is this matter about?
There is a delay, my lord, that's why it has come.
There is no representation on behalf of the appellant. List this matter tomorrow.
18th.
Oh.
Yep. Item number 29. Item 29.
So, my lord, delay is there and some defects are not removed. I am for the respondent.
Item number 30.
My lords, delay condemnation petition is before your lordship of the appellant. The delay condemnation petition is, this has come up for delay condemnation. The petition is before your lordship on behalf of the appellant. I am for the appellant.
Is there any merit?
In that part of the merit part, I am not. I apologize that I am not fully ready to address your lordship.
What is the delay?
Delay is 132 days, my lords.
Why?
I've stated in my petition as regards delay at the level of the university to take a decision where the registrar and the vice chancellor registrar was on leave, and after he has joined, they took a decision which took a bit of time.
So better you come ready.
My lords, I'll do that.
If we find no merit in your appeal,
my lords,
then we may allow your limitation petition.
In fact, I am shaky on that point, to be very frank.
Then we can decide it right now.
No, I would like to take your
All right.
lordships.
Then counsel for the appellate request adjournment. The request sought adjournment. As requested, list this matter on 18th.
The other petition is also before your lordship dispensing with the certified copy, because by the time I had filed this, the certified copy was not with me. So if your lordship grants me some more time, I can procure the certified copy also to be present before your lordship.
1 week.
Item 31.
31, 30, 31 and 32 are the same.
31, 32, 33.
Item number 33.
I want a short adjournment. This is for condonation of delay. This is for condonation of delay. I want short adjournment.
You?
I want short adjournment.
Why? What is the delay?
40 days. Around 40 days. Because I was sick and I have also appended me medical certificate to that effect.
What is the about? This about? What is the matter about?
My lord, the person seeking less mark than me has been appointed, but I have not been appointed in the
To which post?
ordnance factory for the post of DBW. I have secured more marks. I have not been given appointment, but who has secured less marks have been given appointment.
But why your application was dismissed?
Yes.
Why was your writ petition dismissed?
Only because
Really, you could have challenged this order. Why have you come here?
I challenged before the Supreme Court, but it was dismissed.
Then again we pass this, and any order in the review application, you will go again to the Supreme Court. This is an endless. Sorry, we are dismissing it.
There is no permission, Annex 2.
Permission order.
Not permission sought to file review.
Petitioners in the present case seeking review of a coordinate bench decision of this court dated 25/11/2022, passed in WPC number 34400 of 2021. So, against the said order, the petitioner had referred an SLP which came to be dismissed by an order dated 3/3/2023, passed in SLP number 4057 of 2023. It appears that it is apparent from the order passed by the Supreme Court dated 3/3/2023 that the petitioner did not seek any permission to seek review of the order under challenge.
Stop. Next. We do not find any merit in this review application, which is accordingly discussed. Further, comma, there is delay of 242 days.
298, 248, huh? 248 days.
No,
298.
298 days delay in filing the review application.
a review petition.
Huh?
Supreme Court.
We can understand.
Supreme Court passed the order on the 3/3/23.
Yes, yes, we understand. So your limitation will not run from there.
Yes, no, limitation will run for 25th November.
Yes. We are not going to entertain this application, which is accordingly dismissed. Yes.
Item number 34.
My lord, my presence in item 33 for Government of India may kindly be noted. I am Bimbi Sardar, Senior from Government of India.
What happened?
My presence for Government of India in item 33 may kindly be
all right
noted.
Item 34, sir.
In item 34, my lord, there is also limitation, but some merits, I have some merit in that case. My lord. Admitted fact, there is a limitation.
How much?
279 days.
What is your explanation? You can improve your case of by filing supplementary affidavit.
I'll file an additional affidavit that formal grounds are there in my limitation petition. If your lordship permit me, I will file a supplementary affidavit to
Right.
that.
And counsel for the appellant seeks adjournment to give details regarding the reasons for delay in pursuing the appeal by filing an additional affidavit to the application seeking condonation of delay.
Well,
2 weeks.
35.
May I please your lordship? My lord, the interim application is there for dispensation of filing of certified copies under annexure program. These certified copies are available in the writ application preferred for the single mail. The certified copies are of the order sheets of the Tahsildar Kendrapada. And I have taken steps for the following. But these are now also available before your lordship in WPC number 3345/24.
So what do you want?
I think that may be dispensed with.
Hmm?
That may be dispensed with, and my appeal may be taken up. My writ appeal may be taken up on merit.
Is there any merit?
Yes, my lord.
Are you sure?
Yes, my lord.
Just see.
It will take only hardly 5 minutes to explain the merit of the matter. My lordship permit me now, I can place.
4.
19. Yes, my lord. 19/2/24 of learned single judge. But fact is that I have challenged the order of learned Tahsildar Kendrapada on the grounds stated therein. And the grounds are very peculiar. And
Mr. Counsel, you had the forum of appellate authority.
Yes, my lord. Yes.
Did you approach?
But my case is that the fact is that in view of the decision of the Honorable Appeals Court, as reported in Willful Corporation, In the occasion where there is violation of principle of natural justice, this court,
See, the principle which has been laid down in that decision is
minor.
that the court may entertain
Yes.
when there is violation of principles of natural justice.
Your Lordship,
It does not lay down a law that when there is violation of principle of natural justice, appeals should not be filed, only writ petition should be filed. That is not the law. And then one single judge has given you liberty, you should have availed that. And that you have your period of limitation was also required to be condoned. You are not availing that unnecessarily you have filed.
my lord, your Lordship may please to have a glance to page 47 of my brief. Just for a period, 1 minute, my lord. The Tahsildar, without making any date, put up the matter after report is received. When the report will receive, no notice was given to me. Report was received and order was passed. Thereby, that violates the principle of natural justice and it comes under the scope of the.
Sorry, we are not satisfied.
Then your Lordship may please to extend me some time. I will go on.
Counsel for the petitioner, after some argument, seeks permission to withdraw this appeal with liberty to refer to approach the appellate authority. Which item was this? 34.
Sub-collector.
Appellate authority in terms of the direction issued by learned single judge of this court dated 19/2/2024. So this appeal is permitted to be withdrawn with the liberty as aforesaid. First off, we further observe that if the appellant approaches the appellate authority within 30 days from today, the appellate authority shall be required to consider the petitioner's application, the appellant's application for condonation of delay liberally and decide his case on merits.
Item 36.
Here also there is a delay of 700 days. But admitted fact on the same issue that regarding release of RACP.
What is RACP?
Revised Assured Career Progression Scheme. So that regarding some matters were also dismissed here on the ground of limitation. A batch of petitions were dismissed here, madam, that was challenged before the Honorable Apex Court. The Honorable Apex Court has also granted stay that I so similar nature.
All right, we will take up later.
Maybe pardon to make mention item number 53.
46, my lord.
Item number 53, my lord.
From this side, yes, 53. What do you want?
Item number 53 might be, some time may be fixed, my lord, at least after launch, first case or something like that. Otherwise, your Lordship has already had the matter for 5 minutes or 7 minutes, and thereafter it was off time. Therefore, may I pray the same
Let us try on Friday.
Item next week.
Thursday.
Item 66, I pray your Lordship to day after tomorrow or on Friday.
It will come automatically. All the matters which are listed today shall come automatically on Thursday.
My lord, item
46, my lord. Batch of writ appeals filed by the state. There, my lords, my learned friend undertaken that some cases are to be segregated from that batch of writ appeals.
We will see on the next day when the matter is taken up.
In the list to
I have 7 cases. In 7 cases, I am the respondent, my lord.
That will.
I pray that my 7 cases may be segregated.
May
7 cases may be segregated and
these listed are to be.
I have given that each 7 cases may be segregated that
and that may
I have given that list. 6 categories are there. So his 7 cases belong to one category. That list also I have given that. That can be segregated. I have made it 6 categories.
May I humbly pray with your Lordship's leave?
that item number 46, well, more than 100 cases are there. May I humble pray if individual item numbers may be assigned to each case so that there may not be any overlapping of the notings contained in one case. Well, the notings given in a particular case is overlapping. Your Lordship may kindly see the list. If individual item numbers 46, 47, 48, if it is, it would may be convenient for us and for your Lordships also.
47 1, 47 2.
No, it may be also that. 46 1, 46 2, against that one. That is very difficult to address.
That's a good idea.
Item 47, item 47 already argument was over, and my lord have directed to state appellant.
Counsel, every day you blame us.
No, my lord, only my lord have asked to state appellant to produce any judgment if in favor.
All right, we'll see.
Top of the list, my lord.
We will see tomorrow.
My lord, my one prayer, my lord, item 60.
41, I am sorry, Lordship, item 41, your Lordship may take up this matter day after tomorrow, I pray. It is the Chilka matter, pond demolition case. I have mentioned this matter, Lordship. Day after tomorrow, your Lordship.
My lord, I must item 64, my lord. I just file rejoined. 24th, my lord.
Let me come on Thursday.
I will file, my lord. So, I will file on by 24th. So I want that 24th, item 64. Only small.
24.
Item 20.
Item 41 only 1 week after. Okay.
Your Lordship, 41, Lordship may take up
1 week after.
Lordship, your Lordship may take up this matter Thursday. It is urgent. I am the suffering person, Lordship. My pond has been demolished. That is why I pray your Lordship may take up this matter Thursday, day after tomorrow. Learned friend who is submitting actually may not affected, but I am directly affected by the inaction of the Tahsildar Chilka, Lordship. That is why I pray.
No, your item number, your case is listed at which place? What is
that is, it is a batch of matter, Lordship. Item 41, it is a batch of matter. That is why I pray your Lordship may take up this matter. My friend who is submitting.
You are not praying, you are directing. We will see. We will try.
Lordship,
we will try. We will remember.
Lordship.